Your Excellency, in the Court of Human Rights of Europe.
It's a forum on their behalf.
On their behalf, in the European Court. But
the country on their behalf.
Your Excellency.
Dictator on their behalf.
Your Excellency, what we argue. I just seek an extension of a minute to conclude. Thank you so much, Your Excellency. What we argue that as per the charter of this court, private people cannot approach this, Your Excellencies. They have to come through states. So we are championing their cause on the principle of actio popularis. They cannot come here. They are not allowed to come here, Your Excellencies. So the matter to reach Your Excellencies, it has come to someone.
It's a public interest litigation.
On this issue, it is an actio popularis, Your Excellencies. And that is accepted by the International Court of Justice. Your Excellencies, the final argument.
How is actio popularis defined?
Your Excellency, actio popularis is just we as a country acting on a dispute that is affecting a large number of people, and when rights of a large number of people are concerned and they are not able to bring forth their rights before a court of law, we act on their behalf to apprise Your Excellencies of the hardships.
Where did you get this definition from? Actio popularis.
Your Excellencies,
you can research on it and come back.
It has been defined in the Oxford Public International Law Encyclopedia. It has also been reiterated in one of the cases of Your Excellencies. We'll bring that in the further submissions.
Maybe surprised with the definition.
Yes, Your Excellency. Pursuant to the issues 2 and 3, my co-agent will be dealing. Issues 3 and 4, my co-agent will be dealing with the submissions. Thank you so much, Your Excellency. Yes.
Regarding the main contention which was raised from you regarding your locus and what is your locus in filing the present petition, you need to prepare the idea of locus in a much wider perspective.
Yes.
If there is a violation of any human right, if a huge population is suffering, then anybody can come to the court and can raise the issue on their behalf also.
Yes, Your Excellency, that is what
strict locus may not be requiring. So you need to argue in a different way, in a much wider perspective, in a much wider direction to convince the bench that really you are having a locus to raise the point on the behalf of those persons who have been denied entry to the numeraire.
Yes, Your Excellency, that is what I brought forth in the last limb of my argument, that those are private people. They cannot approach Your Excellency.
They cannot, not easy to them to approach to the International Court of Justice for the redressal of their grievances. So that's why you raise the point on their behalf.
Yes, Your Excellency.
That's why you need to modify your arguments.
Surely, Your Excellency.
Reshape your arguments.
Surely, Your Excellency. Thank you so much, Your Excellencies.
It is to tell that the principle of non-refoulement is not a suggestion in the human rights law. It is a binding obligation which is enshrined in Article 33, Clause 1 of the Refugee Convention, which prohibits a state that no state shall expel or return a refugee to a place where their life or freedom would be threatened. Now, these refugees, Argonia, after Argonia introduced the open doors policy, these refugees came from Rio and UKs, which are war-stricken countries, and there's the ongoing war which is going on. Now, Your Excellencies, it is also mentioned under Article 3 of the Convention Against Torture. Judge Pinto, in his concurring opinion in the case of Hesi Jama versus Italy, also mentions that how non-refoulement is a customary international law. And also to mention, Your Excellencies, that Judge Pinto actually acknowledged the contemporary need to balance the national security interests with the basic.
Counsel, one small question, just a very legitimate confusion which everybody. Airplanes. When you want to fly to Pune, I may have to come through Bangalore and stay there and then come here. So you are like a transit spot now. And if you are like a transit spot, is it not your action in drawing these people to your country, which is a far greater violation of human rights than what you are now projecting?
Indeed, Your Excellency, I agree what you say. I agree. It seems like that again.
Please don't agree that easily. Don't agree.
No, Your
You don't have to be
Excellency.
politically correct. You can tell us you are wrong, and you should do that also.
Your Excellency, it seems like a political prerogative, but we are still not conceding that it was a political prerogative, since we cannot relate political prerogatives to legal prerogatives. Second thing, Your Excellency, open door policy was clearly within our domain of introducing open door policy. We are not just transferring people. Third thing, Your Excellencies, there was no asylum request made by the refugees on the borders. Still, we provided them basic necessities, food, water, etc. on the borders. We did not flout any norms of international human rights. We did not step back.
The question is, how did they become refugees when they entered your country? Council, our question is very simple. Take your time. Don't get flustered at all. We will be far more harsh with them also. Don't worry.
Yes.
We know how to be harsh. They don't think, they are sitting there and thinking they're winning. They may not be. But the point simply is this. Once they enter your country on the open door policy, how do they become refugees for another country? You don't get that at all. So are you not in violation of human rights?
Your Excellencies, I very humbly submit that we agree that Numera might have national security concerns. Any person in Compromise 1.1, Your Excellencies, it is very clearly mentioned that Numera is a democracy. Everyone wants to enter Numera. We understand that, and we even appreciate that they introduced the MIAI system to screen people. What we are saying, whatever they are doing, they should do it in a proportionate and a necessary manner. First thing, if the refugees are on the borders of Argonia, even if they are not taking all the refugees, but they should take the refugees which they are taking through MIAI in a more proportionate manner. Second thing, the refugees which they are denying, if they are denying them through due process, we are accepting the fact, we are giving them doors to stay in the country on the border, we are providing them every necessity. However, if they are not doing that, then we have a problem, and then we come to you because it caters to our national security interests as well. This is what I have to mention about the open doors policy and how.
So to remove all the cobwebs, you are a declared country which does not keep you don't give asylum to the asylum seekers. You just give them a station to have water and food and then move on to a better country.
No, Your Excellency.
Number one.
Oh,
Number two, you were happy with the AI system which they had earlier of actually differentiating between a good person and a bad person, which was spoiled by a particular virus, and therefore now you are again concerned with the virus activity as well. So your concern is that when you send a particular person via your country, they are not given the asylum that it deserve because of a certain virus which is spoiling the classification system. That is all.
Your Excellency, I would like to clarify on the second part. But first clarifying, I would like to answer the first limb, which is that we are not a station. We are not, initially we introduced the open doors policy to just give them short-term transit visas to go to Numera, knowing that Numera would follow the
Because you
principle.
don't accept people, that therefore you just give them a
No, we-
conduit to go
No,
to.
Your Excellencies, we do accept the people, but they did not make any asylum request to us. As
Because
mentioned,
they don't find you as a very friendly country. They just come for a short while. You give them a passage to the other country called Numera.
yes. The second thing regarding the MIAI, Your Excellencies, again, how my co-agent pictured it before Shade Fox attack and after Shade Fox.
You don't collect money from these people to be your transit. We were wondering whether you are a consultancy. Like you have this educational consultancy we have. You take people from here, send them abroad, and then collect money for that. You do
No,
that
Your
also. You really wonder whether your economy is now bolstered because of that. You call all people from everywhere. Say that we'll send you to Numera, which is very good. Pay us so much of money. You be in Numera. Numera says we don't want you.
And you clap at the collapsed economy of Numera.
No, Your Excellencies, again.
And that you have any screening for people to enter your country on transit?
No, we do not.
You get the worst. You tell them, the worst come to our country. We'll send you to Numera. What a warfare. Whoever has devised this, your dictator or whoever you call him, is a brilliant
Asylum seekers go to Numera, eat their food and finish off that country. That is
Uh,
your problem.
No, Your Excellencies, it is definitely not a vengeance. Definitely not a vengeance. Secondly,
Because it is retaliation to the various.
I would still not concede to the point of retaliation, Your Excellency. Why? Because
that is what the court gets feeling.
I understand, Your Excellency, but Argonia being
Sanctions
after-
equal to sending people over there.
no, Your Excellency, if that would have been the intent of Argonia at the very first place would not have given any asylum to the refugee seekers.
Oh,
Second,
asylum seekers are not in any manner common to you too. They are just neutral people coming into the two countries. It is just a matter of chance that they enter your country first because they find a footing there. As I told in the beginning, beggars are not choosers. But instead of keeping them yourself over there in your land, on your land, you transfer them to the other country which has imposed sanctions on you so that they may go and eat their food and finish off that country.
No, brother, it is far more sinister. Please read 2.3. It's far more sinister. This is why we say we have actually gone through it within the shortest period of time we have. Don't worry, we are all people with 35 years and more of experience, so don't worry. We are like this in bench also, so don't worry.
Even worse.
Or worse. Please see 2.3. The policy was calculated as an act of migrant weaponization. Argonia deliberately funneled migrants towards Numeria's borders, using them as pawns to retaliate against the West. Then after they entered as tourists, they were sent to certain centers, and then the Argonian officials fed them promises of seamless entry into Numera, exploiting their desperation. And then the far worst thing happens after that. Human traffickers, reportedly operating with the tacit approval of Argonian authorities, further preyed on migrants by charging fees. So you understand why we are asking you.
whether
We have gone through the problem much better than you. And we got it only 5 minutes ago.
That is that like those educationalists, as brother said.
Your Excellencies, I would answer this in 2 points. First, these are only allegations and there are no proofs for the same.
Okay, then please turn to 2.4, the fourth line. Simultaneously, Argonian officials blocked the migrants' return,
Yes,
effectively trafficked them. So you created the problem. You asked them to come, send them to the border, trap them there, do not allow them to come back to your country. And now you are saying, Numero, please take them.
Your Excellencies, alleged trapping at the borders was a consequence of Numera's fortifying its borders.
No. Argonian officials blocked the migrants' return. 2.4, line number 6.
Your Excellencies, again, 2 limbs. First, this happened due to the actions of Numera fortifying its border. The reason because even Argonia is concerned with its national security. We did not close the border for other refugees which are not through open doors policy. We did not keep them in limbo. It is specifically only for the people who come from through the open doors policy for a substantial period of time. The limbo here, Your Excellencies, I would like to note the limbo here only meant we only mean it for a short term period of time unless Numera takes its time and chunks out the refugees through its MIAI system.
If that be so, should you not then send them back to their home countries?
We would be the refouler, Your Excellencies.
Why? Because you have given them only a short-term visa. Please see the problem. It says 2.2 does not say it is a long-term visa. It's like a tourist visa. You're using them as tourists. And if somebody enters your country on a tourist or a short-term visa, and they don't want to be in your country, you have to send them back. It's not defoulment at all. What is the concept of defoulment? Please see the concept of defoulment. Defoulment uses the word F-O-U-L, foul.
Yes.
There is no foul here. There is no defoulment because you have brought them into your country as tourists on a short-term visa. If I go to a country as a tourist and I'm not welcome there, I go back to my country. How can you push them to a third country? Is that not a human rights violation and a breach of international conventions? That you bring people to your country as tourists and then send them to another country, which is a worse form of your international violation.
Your Excellencies, again talking about the limbo part, it was again short term also. Your Excellencies, even if when we kept them in limbo, we provided them all the basic necessities
Gave
that
them
they
biscuits
needed.
and chai or something. We understand all that. But then you created the problem. You drew them from their country, telling them, look, we will send you to a wonderful country like India. But then you couldn't do that. So you are now forcing the country to take them.
We are not forcing Numera, Your Excellencies.
What are you doing? You've created tourists in your country, call them transit migrants, and then push them into the border, created a limbo, as you call it. And that's what they call weaponization. They're sending these people to a country where they do not know what these people will do. What about the rights of the people in the country? A lot of issues are there. And then you are talking about the AI, you are talking about the virus. Now, these are all relevant only if you are able to tell us what really. This is why we put you back on the question of locus.
Issues, again, very simple issue. What kind of prayer you are looking from the court? You call certain person in your country, you trap them, you force them to the border and asking another country to take them.
Your Excellencies, if there have been any asylum requests from the refugees, we were very open to take them. If there are no asylum requests and they only want to go to Numera, and Numera is not complying with the principles of human rights, that's where we come into the whole of locus.
Counsel, what does your country normally do with an overstaying tourist? You send them to some other country.
No, Your Excellency.
Then coming to the root of the matter, you
You
started.
deport or repatriate. That's the normal international convention where somebody comes into your country. If I go to a country for as a tourist, I overstay. They will not transport me to the better country.
As per them.
They'll send me back to my country whether it's good or bad. It doesn't matter to them. You saw planes flying from a country recently. They will just simply send out the people to the home stations in chains if they want to. Nobody can stop them. That's a problem.
Your
And going
Excellen-
to the root of the matter, Article 38, you are also a signatory. You are also a signatory to the to that particular treaty that refugees would be kept safely in your country. Now, you are enforcing a certain contract which was entered into between the words used are the contracting parties. Article 38 to begin with, as I remember. So you are also a contracting party. They are also a contracting party. You yourself treat yourself to be just a interregnum support system for sending them to another country. And then you go about complaining that they are not keeping them properly. And they are differentiating between A and B on a basis which is not admissible to law. So you are the violator, virtual violator.
Your Excellencies, the entire argument stands on Numera's violation of non-refoulement through MIAI. We are conceding to the fact that they have security reasons. Even we have security reasons, and that's how international law exists. Every state sovereignty is a prime thing that takes place. However, all we are contending before Your Excellencies is that even if they are considering their national security measures, they should consider them in a proportionate manner. Through MIAI, they cannot flout the principles of international norms that we are following and they are not following.
What are you following?
By
Which
providing
international norm are you following? Just tell us one norm that you are following.
them basic necessities at the border.
After bringing them as a tourist, putting them in an asylum camp, and then giving them biscuits. That biscuits is international norm. Everything else is good. Send them back to their home country. Why bother Numera? Just have them flown back to their own countries. Collect your fee, whatever you want. And after all, you are a dictator.
So it is just for a short period of time, unless and until Numera complies with its non-refoulement principle, and that's where we come to you when there is a break point. That's what all I have to submit for this. Also, to add, Your Excellencies, it is on our responsibilities too that we do not send them back to the war-stricken countries, and hence we are also open to granting them asylum. But There's no such asylum request from their part.
Go on with that. Go on. You've just stepped on the track that you can possibly.
Fall upon. With the permission of Your Excellency, can I move to my?
Yes, yes.
All right. Your Excellencies, the second limb of my argument is about the force used at the borders of Numera. So, we agree that international law does not impose an absolute prohibition on the use of force in border enforcement, but requires that force to be proportionate and arising out of necessity. However, Your Excellencies, it is to be noted that Numera's use of force has led to injury of migrants and 2 reported fatalities. What we are arguing is that their force is not proportionate in nature at the border.
But is it not commensurate to your president's stated view, which is available in 2.5? Your president said something which is unacceptable, and they have now responded. Please see what your president said in 2.5. It is actually in the bold.
If the West wants to punish us with sanctions, we'll flood their borders with refugees, let them deal with the chaos they have brought upon themselves. This is not a choice.
This is what your president said. What a defiant president. Man
Yeah.
who wants to get Nobel Prize.
Yeah.
I'll flood you with refugees. We are about 7 or 8 billion people.
Without firing a bullet. He's
It
killing
does not
that
have
country.
to. Can send all these people in, and they are all indoctrinated. They can be weaponized, they can be used as weapons, they can be used as suicide bombers. Anything can happen in a country. And that country also has billions of people or millions of people. So now your president says this. They have now responded with an equal amount of force. We believe that your president should be more circumspect.
Your Excellencies, I would answer and counter this in again 2-fold limbs. First, political questions should not be dealt with this court along with the legal questions. Second thing, the political prerogation that this president is doing does not relate
Your
to the entire
argument is
citizens of the state.
we don't know where the platform of politics ends and the politics of legal arguments begin, because this applicant is a total politician. He is killing another country by sending more refugees. It's absolutely political.
Sir, it is given in the advisory opinion construction of Wall case, where the court mentioned that political questions should not be dealt with the court, and they should
We
be
might not be dealing, but you are making us enter into it, and you are yourself neck deep in it.
Your Excellencies, just because the country has an authoritative president does not mean that the state citizen would be put in peril. So we cannot really correlate. Correlation does not really go with causation here, Your Excellencies. With the permission of the Excellencies, can I move forward with my last
Do you
issue?
admit that you created the problem? Do you admit that?
No.
No, you.
No. Your Excellencies, with the paucity of time, I will just go with the issue 4, that is cyber manipulation, in just 3 limbs. So, Your Excellencies, it is to see that Numera presents cyberspace as a battlefield, but the law is not so simple with regards to cyberspace. So, what we are claiming, the allegation that Shade Fox was attributed to us, we do not accept it. First thing, there is no evidence that we have some control or we have some data records with the Shade Fox actor. And the second thing is, we were completely due diligent after knowing Shade Fox presence that this hacking will not work from the Argonian soil. Now, how do I substantiate it, Your Excellencies? For having established to establish that I have not violated their sovereignty, there was no direct control by the Republic of Argonia with that Shade Fox actor. There was no overall control. There was no support from the Argonian government. And third thing, we took preventive measures even after we are not conceding that Shade Fox was a non-state actor, which is attributed to us. We are not conceding, but still, after the mere knowledge that Shade Fox existed in the jurisdiction, in the at the borders of Belavia and Argonia, we made sure that no further attacks take place, and hence, after July 2024, till the time MIAI stopped in February 2025, there has been no such attacks which have happened. The last argument, Your Excellencies, is that, in fact, it is own Numera's action that they have changed their policies in MIAI. First, their own commodification of the data, and second, I would like to take your attention on 5.8 of the compromise, where they refused to cooperate with international investigations. It suggests that they were acting independently and not under any coercion, which establishes my point that I have not violated their sovereignty regarding the cyber manipulation of MIAI. So it shows the conduct on their part, that they were not willing to take any neutral investigations regarding the cyber manipulation, and any such detailed reports, Your Excellencies, which existed, was done by Numeran agencies. That's all what I have to submit for issue 4. With the permission of Your Excellencies, if you do not have any questions, I would like to move to my prayer.
Reserve it when you have the rebuttal, right? You have the right of rebuttal.
Yes.
You can do that then. You hear them so that you can shape your relief after you hear them also.
All right. All right.
Don't get stuck to that relief that you asked.
All right.
You can reframe it.
And that you should always have that often with you. Never shut it up. Keep some cards very secret. How many minutes of rebuttal? 7 minutes. Totally 7. Oh, they have. Okay.
Greetings of the day. May it please this honorable court, I appear on behalf of the respondents, the Republic of Numera, further strengthened in the case of Nicaragua versus USA, where the jurisdiction of the ICJ in contentious cases is said to be founded upon the consent of the parties. This can be inferred by concluding a special
Counsel,
agreement.
if you are confident about your case, if you are confident that you have not violated law and that you are on terra firma on the question of human rights, why are you challenging our jurisdiction?
Your Excellency, because
What is there for you to hide?
Your Excellency, firstly, there are other means of, as Your Excellency rightly
What are
stated.
you trying to hide then?
There is
Why
nothing
don't you
that we are
let us
trying
do
to
our
hide.
job so that we can exercise jurisdiction on the question of human rights?
Your Excellency, according to the treaties and conventions that we signed, the authority does not
Why
lie
do you
with
shy
respect
from
to
the
you.
adjudication which we are going to?
Your Excellency, we are not shy with it. However, now, in this very, our discretion firstly. Secondly, the treaties that both of the countries are bound by state other alternative methods of
Which is the
approaching-
rule that you're referring to? We don't have the rule with us.
Your Excellency, it's Article 80. I apologize, I don't have the bare act of the rules of court. However, it
How do
talks
we know
about.
that?
I'll cite the exact phrasing of the rule, if that is. Your Excellency.
Put it in your arguments.
Your Excellency, the account of counterclaim was raised by the applicant, so that's why we've just incorporated this into our pleadings. And justices. Your
So
Excellency,
you are saying is that the Argonia has approached us directly without arbitration or negotiation. We want to know the rules that you're referring to. We have no idea. We have no access to the rules yet.
Your Excellency, I can provide the bare act. I can give you the exact reading. I have one copy, so I can give that to you.
Does the ICJ have any suo motu jurisdiction in these matters?
Your Excellency, ICJ cannot be the first jurisdictional authority to which the dispute goes. However, after exhausting the necessary remedies, ICJ can be the secondary or the alternate source of remedy, the last source of remedy. This is established.
Now, obviously, negotiation and arbitration won't work.
Your Ex-
Obviously, are we not talking about something that is impossible? Is there not a doctrine of impossibility and a doctrine of necessity?
Your Excellency, there is nothing impossible in this case. We are the victims in this case. These migrants that were funneled
No, the
into our migrants.
impossibility we are talking about is impossibility of negotiation or arbitration. Should we now wait for something which is impossible ex facie?
Your Excellency, as per the case of MK and others versus Poland, which was the Poland-Belarus crisis, as you must be aware of, the ECHR was
We are aware
designated as
because
the,
we wrote the judgment. The
Your
ICJ wrote the judgment, we are aware.
No, Your Excellency, it was actually the ECHR which
Okay, it's
designated it as
ECHR. Okay.
as the appropriate forum for this particular forms of dispute. He did not do that. And obviously, the parties being signatories to certain conventions that say the same, these very conventions give us the alternate remedies. If Your Excellencies would be pleased, I would refer to Article 41 of the ICCPR. It's a principal statute relating to the human rights violations. Article 41 subclause A states, if a state party to the present covenant considers that another state party is not giving effect to the provisions of the present covenant, it may, by written communication, bring the matter to the attention of the state party within 3 months after the receipt of the communication. The receiving state party.
Condition is written communication.
Your Excellency.
You said ki by giving written communication, na? So have you written anything to the opposite party?
Your Excellency, the key point being here is that what does this talk about? It talks about the fact that we are not governing under the effect of these provisions. That is what the applicants contend. Right? Is that correct?
Nidhi, what is your stand on this issue? Na?
Our stand on this issue is that we have not.
You are not subjected to this.
Number
this
one, we are not subjected to the jurisdiction. Number two, there is no human rights violation on our part.
It's a matter of facts ki whether there was an actual violation of human rights or not. First, the primary issue is the jurisdiction. Whether in such matter, whether we can give strict interpretation to the issue of jurisdiction, when there are serious allegation of violation of human rights, having very international ramification, whether strict interpretation or strict definition of jurisdiction can be accepted in this kind of matter.
Your Excellencies, the very international jurisdictions we are talking about, these very international treaties that govern them are the ones that are telling us to go to negotiations, arbitral tribunals, ECHR and so on before we approach the ICJ. That is our sole contention. We consent to that jurisdiction. We say that, okay, whatever resolution is reached between the parties in that proceeding, in those proceedings, we consent to that. We are
It will be
okay with
binding.
that.
Any resolution would be binding on both the country.
Your Excellency?
That resolution would be binding on both the countries.
Yeah, absolutely. The dispute resolution will be consented by both the parties. Therefore, there is nothing that acts as a defense saying, ki, oh, we did not consent to the jurisdiction, so we are not enforcing this dispute resolution. If Your Excellencies are well satisfied, may I move forward? Your Excellency, the treaties that I was referring to, Article 41 of the ICCPR states that, Article 41 of ICCPR states that the formal complaint must be filed with the covenant and within 3 months of receiving the communication.
What are the powers of the ICJ according to you?
The powers of the ICJ. Your Excellency, the foremost matter that we need to consider before we consider the powers are, the foremost power will be the dispute resolution mechanism.
Where are you speaking from? Please
Your
show us
Excellency-
whatever you are referring to.
Absolutely.
The problem we are now facing is that you are speaking from documents in your possession, which we are not privy to.
Your Excellency, can I just pass on the Bear Act?
You should have filed it along with your memorial, right?
You should have filed it.
If at all you are relying
Or
upon
read
them.
it out.
Your Excellency, actually there is a page limit on the memorial, so we are not allowed to exceed that page limit.
Okay.
As per the
Then
rules
he
of
can
the
read it
Constitution.
aloud. Read it.
Your Excellency, Chapter 1 of the ICJ statute talks about the organization of court. Article 1 herein states the International Court of Justice established by the Charter of the United Nations as the principal judicial organ of the UN shall be constituted and shall function in accordance with the provisions of the present statute. Now these provisions range on from 1 to 8.
Take the next one. Take Article 2.
Article 2 says the court shall be composed of a body of independent judges elected regardless of their
Now,
nationality.
there is one provision which talks about our powers. It could be Article 8 or something, if I'm not mistaken. Let your co-counsel look into that and come back to us. Let's forget about the question of jurisdiction for the time being. We'll come back to it. You can just proceed. Otherwise, we'll get stuck there. Purely because of lack of resources at the moment.
All right. So, Your Excellency, our arguments were threefold. Firstly, there is no consent of both the parties. Secondly, I would like to point out from the applicant's memo their statement of jurisdiction. They find jurisdiction under the UN Charter. If Your Excellencies could please refer to...
For the moment, we are shelving the jurisdiction issue. You come to the other
Next
aspect.
issue. All right. Your Excellency, the second issue pertains to the fact of whether MIAI has engaged in any form of discriminatory profiling or have the automated system violated any basic international principles of human rights.
First allegation of theirs is that when they send the asylum seekers, you seem to be ousting them. To begin with, you had come up with an AI system by which you were differentiating between good asylum seekers from bad asylum seekers. This you couldn't have done. And then that was also affected by a virus, which brought in another criteria which was absolutely untakeable. So you come answer that.
All right. Your Excellency is pointing to the first query raised. This adoption of AI in migration control is not newfound. It has been going on. The European Union's border control system. It's a system which uses AI-driven risk assessment
In
management.
the beginning, when you entered into that treaty, or you entered Article 38, all asylum seekers, you can't send people to die, bad people to die, and good people you keep taken and improve your country. It is not normal times. It is a war which is taking place elsewhere, and people are therefore coming to your country.
Your Excellency, first of all, by which authorities, Argonia, the authority by
So you
which they-
attack what they are saying, then commence with
Absolutely. So, Your Excellency, firstly, we would mention that this use of AI in migration control is not newfound. The EU has been using it. The US is using it on their Mexican borders, and the Canadian.
But that is in normal times. Here you are in, as I gather from the literature which has been given to us, and the arguments that it's a war-stricken people who are trying to take asylum.
Your Excellency rightly pointed out it's a war-stricken zone.
So
That is why.
therefore, you can't differentiate between good people and bad
That is exactly why we need to differentiate. If
people
in
who
that
want
war-stricken road
want
we
to
get
save
some.
their lives and they want to die.
Your Excellency, that is exactly why we should differentiate. What if a warlord of that war-stricken country comes into our country and engages in some act of terrorism? That is exactly why we have to differentiate. And by what authorities Argonia, the one funneling migrants towards us, by granting them transit visa with no final destination? Your Excellency, transit visas mandate that there should be a final destination. If today Pakistan has a financial crisis going on, that doesn't mean they funnel out all of their people to India, stating that okay, we don't have the resources, so you go ahead, proceed. That is the entire point here. Now, Your Excellency, moving on, I have established that it is not a newfound policy. Moving on to discriminatory, to the allegation of discriminatory and AI-based profiling. Now, Your Excellency, all of these allegations are their own doings. Shade Fox in July 2024, he came in and he infiltrated our systems. That is what the
Counsel, we will take it for the sake of argument, ex arguendo, that Argonia is at fault in creating and precipitating the crisis of refugees. We'll take it for granted for the time being, ex arguendo. All right, we'll take it there. What should be your response to that? You see, you are now, you project yourself as a champion of democracy. You project yourself as somebody or some nation which is absolutely in upholding principles of human rights. And you also say that you are a destination for immigration and refugees escaping global conflict zones. Please see 1.1. So you have projected yourself to be someone who welcomes immigrants and refugees.
Your Excellency, in response to the same, I would like to state.
No, 1 second, the question is not there.
All right, apologies.
Don't respond to statements also. So just see 1.1. Please see 1.1. We'll tell you the question. Did you see 1.1?
Yes.
Therefore, we will take it for granted, for the sake of argument, ex arguendo, that Argonia has created this problem. We'll take it for granted. What is your response to any refugee issue? Forget it is created by Argonia or otherwise. It could be something that is not created by anybody else. It could be something that is sui generis or something that has happened on account of geopolitical tensions anywhere in the world. What is your response to a refugee situation?
Your Excellency, we don't act as the absolute good Samaritan saying that all refugees are welcome herein.
Is that a
Obviously,
confession or is that a statement?
Your Excellency, that will be a statement.
We wonder why lawyers are making confessions against themselves. Both sides are doing that. One says, I am a dictator. The other says, I am not a good Samaritan.
Your Excellency, in the interest of national sovereignty, it is within our rights
We
to follow the
understand
due
that.
process.
That is why, Counsel, we asked you, what is your normal response to a refugee situation? Forget about this. Forget about this Argonian precipitation. We understand your problem because you have heard the way we grill them. That is why we said you are not going to have a rose petal walk.
Very well.
You will have a problem. Now, that's why we are asking you, what is your response to a refugee problem anywhere in the world? Because we understand that you are one of the foremost countries of the world. And you are part of the coalition of the European nations also. So what is your response normally? Do you screen every refugee? And or was this particular tool intended to screen only the refugees in this scenario? Just want to know that. And then we'll take you through the other questions we have.
Your Excellencies, we will allow the migrants, as we did in this case, however, after the necessary screening.
No, our question is this MIAI or whatever you call this?
MIAI.
Is that only for this particular scenario? Or are you using MIAI for all the refugee applications that you get?
Your Excellency, in the present scenario, in the present time frame given to us, there is only one migration dispute that is resident, and that
It's
is
not a
when-
question of dispute. That's why we are asking you. Forget a dispute. Assume that there is an application by a refugee or applications by a set of refugees from the war-stricken zone. What is normally your response? We just want to know that.
Your Excellency, our response would be to allow the refugees. However, with the necessary screening done. That will
Is that
pertain,
screening done by this MIAI? That's the only question.
Your Excellency, that is a future event we can't contend to right now. Currently, it is only being for the migration crisis being, and the only migration crisis being faced right now is with these migrants.
Okay.
So that is a future contention. We can't say
So
anything.
what brother is asking is, what is first, what is your philosophy vis-a-vis refugees? What should the countries as a whole do? And then what is your own policy?
Your Excellencies, as rightly pointed out, we are one of the prominent members of CEN. We uphold the principles of human rights, refugee rights, and so on. We will obviously allow the refugees in a normal scenario as well. However, in this instance and other instances as well, there may be criminals, terrorists, and so on of that land, of CEN's database that may come in with that, with those migrants. It is necessary that we have a say-so in who we let enter and who we don't let enter.
Is it your case that why doesn't Argonia keep all the refugees, and why they are sending them to us, to you?
That is our contention. They have no authority.
So contend it that way.
Your Excellency, I intended to contend that firstly, Argonia has no authority to firstly gather these refugees from around the nations, the neighboring nations, and throw them into our no man's land. And Your Excellency, it is notable that we are allowing entry to at least a few refugees. They have absolutely shut off their borders.
Now,
saying that
Council,
you
will
should not-
ask you once again. We thought you would have seen 4.3. There is an allegation that your MIAI screens people based on ethnic and religious backgrounds. Our question is this done for other refugees scenario also? That's the only question.
Your Excellency, this is absolutely not done by us. I will, in that exact same paragraph, if you read the fourth line, matters worsened by the end of July 2024. Now, Your Excellency, in reference to the corrections and clarifications, clarification number 21. Are Your Excellencies with me? Clarification number 21 asks, when was the ShadeFox introduced into MIAS server? ShadeFox was introduced into MIAS servers before July 2024.
No, we'll deal with the ShadeFox scenario secondly. We are talking about the pre-ShadeFox scenario. So let us know whether the allegation that you are screening people on ethnic and religious backgrounds are right or wrong according to you.
Your Excellency, that allegation was not raised before the entry of ShadeFox into our system.
Of course,
all of
yes.
that has happened
Please see
after
4.3.
ShadeFox.
No, please see 4.3.
Yes.
4.3 is before the ShadeFox thing.
Your Excellency, should I quote it?
Just read 4.3.
Absolutely.
There were allegations that you are flagging large number of migrants from specific ethnic and religious backgrounds. Now, this cannot be allowed anywhere in the world. This is an international problem.
Your
So the
Excellency-
ICJ may step in also.
Your Excellency, this cannot be considered an isolation. That is my entire point. The very next sentence states that all of these policies started to appear after July 2024. Now, when was ShadeFox introduced into our
No, the
system?
matters worsened by the end of 24. But there was an allegation earlier also. This is why the first question came to you. Listen to our questions because those questions will have relevance. We asked you a question at the beginning, whether this is the same policy that you have for all migrants and refugees. And that question was asked to you with a specific intent in mind. Though we keep our sleeves closed for some time. The cards are here within. So therefore, your 4.3 clearly says that MIAI had a problem, flagging people based on ethnicity and religiosity, which is not something that the ICJ will definitely countenance or agree with. And then that was made worse with this ShadeFox. We'll come to that ShadeFox thing later. So we're just asking you whether you are doing this, whether the allegation is right or wrong.
Your Excellencies, I would just like to clarify that firstly, all of these allegations, all of these fallacies appeared in July 2024. That has to be established firstly.
You
Secondly,
can't just stick to that point and simply refrain from our question.
Your Excellency,
Please see 4.3. Why are you not seeing 4.3?
Your Excellency, I have it open.
If you have it open, please read it and let us know. Don't read it, but let us know.
Your Excellencies, our entire contention is that the system was not flawed before that intervention.
Are you saying that these allegations were not true?
These allegations were not true.
That's all that you have to say. So according to you, when AIMI was doing well, there was no such problem.
Absolutely.
It is ShadeFox which created the problem.
Absolutely.
That's what you're saying.
Absolutely.
Stick
And
to
Your
that.
Excellency, this is not without merit. The clarification clearly states that these issues started in July 2024 and ShadeFox was incorporated before July 2024. That is when everything is
But your
apparent.
MIAI had an unpatched vulnerability. Because that is how ShadeFox is able to use it. So the program that you created was very vulnerable.
Your Excellency, it has been recognized in the Talent Manual 2.0, which states that AI is a vulnerable black box technology. It has its inherent flaws. However, it is upon the countries using it that upon intimation of these flaws, we patch them up. We perform
That's
the
what we are
reforms
saying. So there was an unpatched vulnerability which was actually used by this shade fox or whoever it was.
Your Excellency, there was
And
no
if that was the
unpatched.
way it was, then how do we say that your AI tool was beyond, any error?
Your Excellency, first of all, there was no unpatched regularity. That the way that the update systems that we throw into our systems to update them, that patching mechanism was used to get into the system. Firstly, that. Secondly, it again, as stated by the Talent Manual, the reforms need to be measured. The reform measure should be taken after the intimation of the patch. If there was arguendo, if there was any issue in ShadeFox, we were informed of it and we patched it up. That is the entire contention. It is also reflected in the clarifications last page. Our Prime Minister's statement states the same. Your Excellency, may I proceed? Your Excellencies, with regards to the contention of discriminatory profiling and any bias in algorithmic bias. Now, Your Excellency, this contention is not found into the compromise. All of these were inculcations of shade fox. Now, it is stated in the case of
Council, don't rush. Please see 4.8. The
Yes,
fourth
Your
line. Please see the third line and the fourth line.
yes, Your Excellency.
The code that was inserted by Shade Fox, it was only manipulating the weights assigned to various risk factors, amplifying the importance of ethnic and religious data fields.
Your
So
Excellency.
there was already an ethnic and religious database or data field, and you are saying that it was not there. And those data fields were intended to tell you which kind of ethnicity should be allowed in and which kind of religious preferences should be allowed. This is why we asked you. There was an allegation that MIAI, as it stood even before Shade Fox entered, had religious and ethnic biases. We are in the on the realm of international law. We are asking you as human beings concerned about human rights, how can such preferences be accepted?
Your Excellency, the very next paragraph herein states that border agents reported an unusual surge in high-risk alerts from migrants from certain regions, triggering detention and deportation on an unprecedented scale. The system designed to sift through nuances now operates with a blunt discriminatory edge. Now operates with a
You are
blunt
now
discriminatory
arguing
edge.
like a council we meet in court, real court. You are deflecting everything that we ask. But our question is simple. The problem precisely says that Shade Fox amplified certain data fields, which presupposes that there were data fields of ethnicity and religiosity. We are asking you as a democracy, how do you justify it?
Your Excellency, again, as reiterated previously, all of these were inculcations of Shade Fox. Now, as Your Excellency stated the paragraph, we go on with the system now operates with a blunt discriminatory edge. It happened, all of this
See, as a
happened
council,
after-
you should remember that the question that we ask will still be in our mind, whether you take us through another one. You have taken it's a deflection. It's like the missiles that you fire a missile, you fire a flare, the missile goes behind it. But we are not like that. The missile still comes at you. The flare simply vanishes. Because we are very persistent, That's a problem with the ICJ.
Your Excellency, the data fields that we are using, they were just for surveillance. Now, again, per this surveillance, the applicants contend that we engaged in mass
Ask you a
surveillance.
direct question. Why did you have ethnic and religious data fields?
Your Excellency, we did not have any ethnic or religious interface. However, the documents that we were used were data pools of the CEN. All of us are democratic nations supporting the human rights community. If there was anything in that data set that was a part of the CEN's database, we cannot be held liable for the entire CEN. We are using their database at the end of the day. Besides that fact, we also asked the migrants for a government identified ID card. Now, we are within our rights to ask for necessary documents before us granting them asylum or entry into our nation. That has been established. Now, Your Excellency, in a very similar tangent, we will take an example. The Sikhs keep the Sikh religious community of India, they keep Qatars. However, it is also mandated in our Indian judicial system stating that you cannot carry an active weapon on your body the entire time. The Qatar is an exception to this through this provision of the law. We are within our national sovereignty.
We didn't get the purpose at all.
Your Excellency, the idea is that there is national sovereignty involved. There is some religious backing involved.
No, that's why we asked you a specific question. That's a direct question. You justify religious and ethnic data fields for your national security. If you say yes, that's the end of the game.
Your Excellency,
Your problem is that you can't say yes, you can't say no. So you have to say something else.
Your Excellency, at the end of the day, these are all allegations. Allegations are not proven yet. Once they are proven, it may be established that there was religious database involved and it may be our fault. However, the database we are using is the CENs. The CEN in its entirety will be held at firm, which is equivalent to the EU in this case. Just imagine the broad variety of litigation that this would introduce if such a contention was allowed.
So you
Wait for
agree,
it, it's likely to happen.
so you agree that you will give the asylum, but after vetting,
Absolutely.
which they don't do.
Your Excellency, that is our entire contention. They grant transit visas. Let's say today someone wants to go from Bangladesh to Pakistan. India will grant them transit visas. Now, India has the mandate to enter the final destination and know the final destination. In this case, the applicants very blatantly place that entry into the West. Their exact verbatim by the president is entry into the West. Now, the West can be such a broad term. It can be a direction. It can be a group of nations. It can be one particular nation. Nothing in that states that Numera is the ultimate destination to these migrants. That is our entire contention. It is not upon us to give entry to all of them. If any of the refugees or migrants that they have funneled into their nations, what is the means of closing of the borders from there and saying you won't get any re-entry from our nation?
First question we asked you, we agree that Argonia created it. What is your response to the refugees? Abstract sense, what is your response to refugees? They're human beings. You are a country which champions human rights. So assuming that Argonia creates this problem, you can't let people die at the borders.
Your Excellency.
So how do you respond? That's the first question that we asked you.
Your Excellency, as showed in the compromise, we have engaged with human rights organizations. We have complied with our international treaties and obligations by granting a certain section.
Why don't you accept them and then deport them?
Your Excellency, it is not upon us. This is a huge population that we are talking about. They enter our nation, cause abrupt violence.
Then how different are you from Argonia then? If your response is same as Argonia, how are you different from Argonia?
Your Excellency, it was not upon us. We were not the initial.
We agree.
We were not accused of entering.
We
are
agree.
the victims.
We agree.
Your Excellency, we reached a dire state where we had to declare an emergency. Those are the circumstances a nation can be at.
Okay. Your co-counsel can now start.
Your Excellency,
Do you have anything more to add?
Absolutely. Your Excellency, we would like to engage and put it in the information of the court that according to clarifications last page, we have inculcated the necessary reforms as per only the security breach that was inculcated by the applicants. Now, our entire contention is all of the discriminatory practices, all of the AI-based profilings were inculcated after Shade Fox. Now, the basic contention, if Your Excellencies would allow me to plead back to jurisdiction, I would like to cite the memo of the respondents in the statement of jurisdiction, if Your Excellencies allow.
No, we are continuing to hear the matter. Don't worry. So we'll hear your co-counsel and then we'll come back to you.
All right. Much obliged. Your Excellency, may the co-counsel approach the dais. Greetings to the chamber.
Your Excellency, may it please to the Honorable Court, this is agent number 2 and I appear on the behalf of respondent, the state of Numera, and I will be addressing the issue number 3 as well as the issue number 4. Your Excellency, the issue number 3 pertains to that Numera has not breached any international obligations regarding the treatment of refugee. Your Excellency, the agent would be summarizing it, will be submitting all the arguments pertaining to issue number 3 in threefold manner. Firstly, that Numera has complied with all its obligations under the Refugee Convention. Secondly, Numera has complied all its obligations under the Budapest Convention, as well as thirdly, we have not violated any of the obligations as under the Convention Against Torture. Your Excellency, starting with my first submission, that the Numera has complied with all the obligations under the 1951 Convention, Refugee Convention. Your Excellency, the state retains the sovereign right to regulate its entry as well as the removal of any person, a non-national, provided it adheres to all the international obligations. Your Excellency, the agent would like to mention on the compromise page number 7, para 3.5, Your Excellency.
No, we have no problem in you having methods to screen the kind of people that enter the country. No problem there. Don't argue that. I don't think there can be any case where a country must let everybody enter.
Yes,
That
Your
is not the way it is. But otherwise, we wouldn't require visas.
Yes, Your
That's not the case. The case is whether the standards that you have placed for that answers the requirements of human rights. Please understand the background in which we are asking you. Please don't argue the obvious. The obvious are some things which we cannot say no to. The question is whether the standards that you have kept, what are the standards? You're screening people on ethnicity, you're screening people on religious preferences. Is that really what answers the requirements of human rights as an inalienable right for every human on this world, for all the 7 or 8 billion people? That is the first question. Now, your argument is that they have precipitated a particular issue or a scenario, a factual scenario. So you are saying that because they precipitated it, we have nothing to do with this. People may die. It doesn't matter to us. Would that really answer your own, standards of human rights that you are proclaiming to the world as one of the major countries? That's why we ask your co-counsel, what is the difference between Argonia and Numera then? If Argonia says, I'll pump refugees to you as foot soldiers, you say we will not accept them and let them die because you created the problem. How are you different from Argonia from qua the human rights angle? This is the question we are asking. Please analyze the problem that is now in front of you. Don't say Argonia put the people on us. We will do nothing to do with them. Yeah. So how, as a world leader, how will you resolve that issue? You call yourself a world leader, a world democracy. Argonia, they themselves say is dictatorial. They say we cannot be rectified. Don't worry, we are bad. They say that. How do you say that you are also bad?
Indeed, Your Excellency. To answer that, thank you for the question first of all. Your Excellency, Your Excellency itself stated that in the para 1.1 that the state of Numera is a democratic country upholding its principle of human rights, and we are known for principles of human rights. Your Excellency, to tell that the difference between the state of Argonia as well as the Numera, the Excellency in the claims of the applicant stated that quoted a line from the compromise, they have closed all their doors after pushing them to the no man's land.
You are not the applicant.
We are the respondent.
You are not the applicant here.
Yes, sir.
You are the respondent.
Yes,
Your
Your
respondent.
Excellency. Yes, Your Excellency.
So what they do, it's their problem.
Your Excellency, the agent is somebody quoting that what Excellency also, which is also mentioned in the compromise, that they closed all their doors and.
What do you do to the people who come to you?
Yes, Your Excellency. We are seeing that a huge human rights violation are happening. We are allowing the people, as the Refugee Convention also lays down certain criteria. On basis that only the people, Your Excellency also said that the.
If you are a champion of human rights, how is it that you take advantage of this? Now, there is an allegation that you are taking advantage because you are now making money out of confidential data. This is what really worries us as members of the ICJ.
Yeah.
Because you are now saying that you will screen the people, get all their information, and put it out to the international, perpetrators without any care for their privacy. Just because they are refugees, are they not humans?
Yeah,
when you are talking about human rights, is there a difference between refugees or non-refugees? So these are the angles that we want you to answer if possible.
Yeah.
Don't give us the obvious. We know the obvious. To say that I have a right to screen the people who enter into my country. But suppose you say, I will only take black people and not white people. Or the alternative, I will only take white and not the black. Is that really a standard for a democratic country?
To answer that, may I answer that, Your Excellency? We are not at all discriminating on any of the ethnicity, religious basis, or any sort of discriminatory matters. Your Excellency pointed out to my co-agent the line from para 4.8 that the code of manipulated the weights assigned to the various risk factors. That risk factors were incorporated as a democratic country.
That makes it far worse.
Your
You are
Excellency-
now saying certain ethnicities are more dangerous, certain
No,
religious
Your
groups are
Excellency.
more dangerous. That is a standard stereotype that you create.
Your Excellency, may the
Please understand the problem that is before you.
yes, Your Excellency.
You can answer this in several layers. Everything that you say, there will be a counter question. It's very easy.
Your Excellency,
So that is why we are asking you. You are saying we are assessing the risk factors.
Your
Is that right?
Your
Your
Excellency,
AIMI was supposed to be to assess the risk factors. Are you virtually not saying that certain ethnicities are more risky to us? Certain
No.
religious nominations are more risky to us.
Not at all, Your Excellency. The factors was incorporated just because there are various religions as well as the various customs which they practice. We need to ensure that customs do not lead to MIAI detect them as a high risk factors.
Please see 5.4 then.
Yes, Your Excellency.
It painted a damning picture of Numera's governance.
Your
It's a very severe castigation. While publicly championing MIAI as a tool of humanitarian security and technological innovation, the government had covertly exploited the system to generate substantial illegal revenue. What human rights are you talking about then?
Your Excellency, these are the arguments of the state of Argonia which they have alleged that we have done. Your Excellency, that reports are not on the basis of anything they have stated, like where from they have that got it. But Your Excellency, the agent would like to mention the clarification second last page, the speech of our Prime Minister. Your Excellency, the second in the para, our Prime Minister has said that we have incorporated an independent international committee which held that there was no allegations on our government officials. We have not done any sort of that practice like taking revenue from or taking any discriminatory practice. We have the basis of that. Independent cyber security experts have taken the reports as well, Your Excellency. But the arguments of the state of Argonia are not backed by any of the reports or any such committees, an independent committee or cyber security experts reports, Your Excellency.
And in 6.5, it says that Argonians, bribed your officials to manipulate MIAI.
Your Excellency.
Your own officials, they manipulated.
Your Excellency, they have not
And that is
backed any
part of
report.
Annexure D, which is a project report officially published in January 6, 2025, very recently.
Your Excellency, these reports are baseless. They have not backed any of the reports from any of the data, from where they have deprived the data, from what are the sources of the data. But our Prime Minister clearly in the clarifications, it's also mentioned that an independent cyber security expert teams, we are not, that's the reason we said no to the Urian cyber security, because they can allege that we, as a
What
Urian
was
nation,
your counteraction to this? What fox? Shade fox.
Shade Fox, Your
So
Excellency.
what was the counteraction?
We are doing a regular AI system. As a democratic nation and the values we value, we never intended, we never want any of the person to do anything. Your Excellency, the clarifications I also wanted to mention that administration remains unwavering in its commitment to the transparency, justice, and security. We have intended a comprehensive review.
I would have completely agreed with you.
Yes, Your Excellency.
Had we not read 5.1. 5.1 5.1 are the reports of the CIA. So when you were arguing, you were saying everything is an allegation made by them. We stand with you initially, but then please read 5.1. They are not allegations anymore.
Your Excellency, the reports of Cyber Intelligence Agency are just pertaining to unauthorized.
No, Central Intelligence Agency.
Yes, your
And then they say that they implicated Numera itself in a web of clandestine activities. As cybersecurity experts probed deeper into the compromised system, discrepancies began to emerge in MIAI operational logs. And then, please see 5.2. Further analysis revealed that the vast amounts of biometric, behavioral, demographic data were being siphoned off to obscure endpoints. These are not allegations. These are the results of an investigation.
Your Excellency, the Central Investigation.
Please see the next line. What was initially dismissed as a byproduct of the Argonian hack soon took a darker implication when investigators discovered encrypted communications between high-ranking officials within numerous government and the shadowy organizations. You have any idea what is happening in your country now?
Your Excellency, if may I summarize.
Something is rotten in Scotland. Badly.
Your Excellency, the Central Investigation Agency in the present case, there's nothing mentioned in the compromise whether
Is
it
it
is
your
an
agency or
independent-
theirs?
Exactly my point, Your Excellency, that it is not been mentioned anywhere whether it's an independent or
If
not.
that is the case, then you surrender, you agree to it. You
No,
say,
Your Excellency.
So you say we are accepting
If-
all the people who are seeking asylum. Number one. Number two, we are not refusing anybody. Number three, you say our AI was only to the extent that it did away with human bombs, with people who are creating troubles, that is all. So you surrender, you stick to your Prime Minister's speech.
Your Excellency, if the Central Investigation Agency would have been our agency, we should have ensured.
What is the CIA? We did not get it. We thought it was an investigation that was engineered by you, commissioned by you.
No,
How
Your
can anybody
Or
commission an
neutral
agency into your country?
It is not been clarified as well, like whose agency it is. It is
Why?
most
Because
probably-
they have access to your systems. Please see 5.3. The breakthrough came in first week of October when analysts decrypted fragments of the stolen data's routing records, exposing an intricate network of transactions. These revealed that MIAI data, originally under the national security, has been commodified. Now, these are all investigations that were done with your permission.
Your Excellency-
Corporations specializing in targeting advertisement, surveillance technology, even behavioral modification tools had purchased the data at exorbitant prices. Most disturbingly, certain records implicated illicit bodies. We are not sure if you had really read paragraph 5. It really, damns you so badly.
Your Excellency, if the Central Investigation.
And because of that,
Yes,
we
Your
first took you to 5.4. I was under the impression when I asked you to read 5.4, you would read at least 5.1 to 3. You have not done that.
Your Excellency,
These are no longer allegations, Counsel. And we will not accept that these are mere allegations anymore. This is part of an investigation.
Your Excellency, the basis of Central Investigation Agency is not clear in the present case.
We do not know. It is for you to tell us.
Your Excellency,
CIA must be your own agency.
no, Your Excellency, it's not our
Where do you
agency.
say that? Where have you said that it is not your
If this would have
agency?
been our agency, we would have.
Then how did
ensured
that agency
that-
get access to your computers and your systems?
Your Excellency, the Shade Fox also get they did a cyber attack on our systems, and we are ensuring that an investigation. will be
According to
done.
you, even investigation was done clandestinely. You are not aware of the investigation.
Your Excellency,
So come up with your case. What is your case?
Your Excellency,
In the end, you say that you are all for human rights. You are all for allowing all the asylum to be there. You are not in any manner discriminating any particular person seeking asylum from the other person.
Your Excellency, as a
So if that is the case, you surrender.
Your Excellency, as a democratic country, we believe in an independent agencies. To mention that, Your Excellency, we to ensure that there is an independence, we denied to the Eurasian cybersecurity experts as well, because we are in a Eurasian country. If we would have to have it in our favor, we would have allowed them to have an access and do an investigation. But it would be unfair on the part of Argonia. As a democratic country, we follow the principle of equality and all that, and we ensure that there is an equality. That's why we denied them. and ensure that an independent agency do all the investigation. That's what's mentioned as well also. The investigation committee I authorize, composed of a leading independent cyber authority. That is the main contention the agent is trying to place before the chamber, Your Excellency. Your Excellency, if Your Excellency is satisfied with the answer, like,
You will not be, because you did not read 6.2, which is in your favor. This is the problem. Now we are becoming your counsel.
Your Excellency,
Please read
much obliged
6.2.
much
You should
obliged
have,
for that.
when you understand that a question is being posed to you, please understand that there is a counterpoint. Please see 6.2.
Yes, Your Excellency. The
That validates you.
orchestrated.
My brother was
orchestrated-
asking you to surrender. You should have said, I won't surrender. Look at 6.2.
Yes, Your Excellency. I was coming on the point. Like, I
No,
have
you were not
mentioned
coming
it.
there. Come on, read 6.2.
Your Excellency, Numera defended his action, asserting that the border breach was an orchestrated provocation by the Argonian operatives aimed at undermining Numera's security. Your allegations also suffered of a cyber manipulation of MIAI surveillance system, MIAI, which was an integral to the border management system. Your Excellency.
Next line, the top portion, that is in your favor.
Subsequent forensics investigation substantiated that the Numera's claims revealing that the cyber attack originated from the server which was within the jurisdiction of the Argonia, and the much obliged, thank you so much. To mention that the council, the agent would like to also mention that there is a convention. We have also not violated any other convention, including the Convention Against Torture. Your Excellencies, the principle of non-refoulement under the Article 3 of Conventions Against Torture applies only when an individual demonstrated a foreseeable and personal and real risk facing in the current case. Your Excellency, the agent would like to submit one of the cases of the NA versus United Kingdom, where was a Tamil person was being who was an asylee in the United Kingdoms, but he was deported from there to the country of Sri Lanka. Your Excellency, the main contention held by the chamber in that case was a real risk of violence or instability is insufficient to invoke non-refoulement principle. Your Excellency, the burden of proof lies on the applicants to demonstrate that a specific and a personal risk of torture is there present. In the present case, Your Excellency, the Argonia gave them the transit visa with, as my co-agent also mentioned, that without knowing where they were going, the final destination. So they, without any basis, they gave the transit visa. And to also mention, Your Excellency, the refugees were given the entry from the war-ridden zone to the state of Argonia. Then why there is a discrepancy in the present case that they are trying to enter the state of Namibia? Like, we are also allowing that they face a real risk, but to mention that the agent want to mention that the state of Argonia has closed its border completely. After seeing that such a torture is being happened on the people, they are dying due to food, shelter, and everything. In certain cold weathers, they are not even allowing anyone.
Precisely. Should you not then intervene?
Your Excellency, we have intervened. We are allowing the people on the basis of assessment.
Otherwise, what is the difference between Argonia and Numera?
That's exactly.
If Argonia lets people die and you also let them die,
of course,
how
our
do we
nation
pick
won't
between
let
the two of
people
you?
die, Your Excellency. As a democratic country, we value their lives as well. Each and every life.
No,
counts.
you are not valuing life. You are valuing ethnicity, religious, and all that.
No, Your Lordship, we are not discriminating any person on that basis. Was the MIAI that it was the, Your Excellency, the Shade Fox actions, it's cyber attacks, which leads to MIAI to have that problem in that. But we are trying to resolve it, and we ensure that no such discrimination will happen. The basic code of MIAI is ultimately a AI, which has been fed from the human people only. The humans only codify it and ensure that MIAI will not go beyond what it has been codified. So our country it's our own mechanism, and we have not codified it to discriminate on any ground. Whether it be racial discrimination or religious, sex, gender, anything, we are against it and discriminating.
What is your point of discrimination?
Your Excellency, we do not.
Your speaker number 1 said only dangerous people were being ousted.
Yes, Your Excellency, as the Refugee Council
But
Convention.
here comes the question, why even dangerous people be sent to a warring country, war-torn country?
Your Excellency, to mention, I would like to quote Article 1F of the Refugee Convention 1951. It states that the non-refoulement principle will not apply to any person with respect to whom he or she has committed a crime, he or she has committed a political or non-political crime which is of a serious nature, and prior to his coming to the country, he has done any of the crime which has been recognized in that country or any other country. So on that basis, we are not allowing the as following the refugee convention.
Discrimination is only till that.
Yes, Your Excellency, on the basis on the crime. At the end, we have to ensure that our citizens also safe, to ensure that our national security is also being taken place, along with human rights are not also being violated, Your Excellency. Your Excellency, if Your Excellencies are very satisfied, the agent would like to move on the issue number 4, which states that the alleged cyber manipulation of MIAI violates the state sovereignty of the state of Numera in the international law. Your Excellency, I would like to quote the full bench of the Honorable Courts itself, one of the judgments of the full bench of the ICJ. Your Excellency, the name of the case is Nicaragua versus United States of America. In that, the Honorable President of the the ICJ mentioned gave the definition of sovereignty. Your Excellency, the sovereignty in the context of an international law means a state's supreme authority and independence to govern itself, both internally as well as externally. Your Excellency, it is to mention that it is the sovereign function of our nation to ensure our defense system, to ensure to whom we should give entry to ensure that human right principles are also being upheld.
Referring to the 1984 ICJ.
Your Excellency, yes, Your Excellency.
That's a military and paramilitary actions against.
Yes, Your Excellency.
Bracket Nicaragua versus USA.
Yes, Your Excellency.
1984 ICJ. That's 1984 ICJ.
Yes, Your Excellency. To submit.
How are you using that in this particular context?
So, Your Excellency, that to answer that gave the definition of sovereignty that the agent mentioned. Along with that, I made a 3/4 submission in the further issue. I will be giving the Nicaragua versus the United States of America, the context of that as well.
Is that
If Your
with regard to
allows.
1F?
Your
Is that
Excellency?
with regard to 1F?
No, Your Excellency, it's a separate. The issue of sovereignty is the present.
That's a sovereign country has its own rights to oust people who are
Yes, Your
of a
Excellency.
criminal nature. That is 1F.
Yes, Your Excellency. That is one of a Refugee Convention 1951. Your
And then in
Excellency.
2015, Costa Rica went against Nicaragua.
Yes, Your Excellency.
Are you aware of that? The next judgment.
Your Excellency, the landmark judgment.
Nicaragua went against USA.
Yes, Your
Costa
Excellency.
Rica went against Nicaragua in 2015.
Your
They
Excellency,
made far more worse allegations.
Nicaragua versus USA also went against in the 1986 judgment as well, Your Excellency, after that as well. To mention a recent judgment as well of the 1999, the prosecutor versus the Bridget judgment, the facts was like that the government was accused of genocide. The state was charged with orchestrating the ethnic cleansing of a non-Serb in their republic country. The case examined the admissibility of the illegal obtained evidence as well, with the court ruling that such evidence could be admitted in its proactive values, overweighting any procedure irregularities. So Your Excellency, submitting in my first submission in this is that the unlawful evidence obtained by the state of Nicaragua should be admitted in the Honorable Court of ICJ. Your Excellency, the Republic of Numera submits that the evidence should be admissible before the ICJ, as international law does not impose an absolute bar on such evidences. Your Excellency, Article 48 of the Statute of ICJ also mentioned that the court shall make orders for conduct of the case, shall decide the forum and time in which each party must conclude its argument, and make all arrangement connecting with taking the evidences. Your Excellency, to mention that unlike the domestic legal systems, the International Court of Justice have never adopted a strict exclusivity rule in the present case. Your Excellency, prioritizing material truth over the procedural concerns. to mention that, Your Excellency, the Nicaragua state versus United States of America.
Does that not go against you on the question of jurisdiction?
Your Excellency,
Does that not go against your own objections on jurisdiction?
no, Your Excellency. The point the
You are
agent-
giving us such an amount of leeway, so we can consider this even against your objection of jurisdiction.
Your Excellency, we are just submitting an arguendo secondary opinion to protect our state's claims as well. Like we are not allowing that we are not. Like we are saying that there is no
Now it's
jurisdiction.
slightly sinking into you. So
Yes, Your Excellency. Like,
understand that.
we are just protecting the claims of our country. Like we are stating that we are not accepting the jurisdiction, Your Excellency. To mention the line of Nicaragua versus United States of America, Your Excellency, I will quote the lines of the Justice. Relevance and probate value should be the primary consideration in determining the admissibility of any evidence, whether it should be lawful or unlawfully obtained. The main contention here the agent wants to state is the evidence directly proves the Argonia's cyber operation and inferences in Numera's internal affairs, which is our sovereign right to regulate our defense borders. Your Excellency, excluding it would shield Argonia from accountability and deny us a fair adjudication. Your Excellency, to mention that the shade fox is an act as an attribute to a state towards the state of Argonia. We like to mention that the control test is established by the honorable bench, honorable court of ICJ. The effective control test was established in the same case of Nicaragua versus United States of America. It places a 3-point test. Your Excellency, the first is any organization to be it should be a state organ, or secondly, it can exercise the element of government authority which will make it the liability of the state. Thirdly, Your Excellencies, it should exercise a direction or a control over the conduct of that organization. Your Excellency, this was later incorporated in the rule article on the responsibility of states.
but how do you say that these criteria are retracted here? You're talking about the control doctrine.
Yes, Your
You're trying
Excellency.
to say that Argonia controls Sage Fox.
Yes,
We
Your
understand that.
Excellency. Yes, Your Excellency.
And you are trying to bring in those 3 criteria and to make it discernible to us that Argonia is now intervening with your sovereign functions. We understand all that. But what are the criteria that you have attracted or you say are attracted in the case of Shade Fox?
Your Excellency, if we see the annexure D on page number 20 of the compromise, that states give the talks about their state and between them, that they did the planning, their land was used to attack on, their servers were used to attack on our MIAI system.
If you were aware of that, why didn't you approach
We were not
the
aware.
court first?
Your Excellency, we were not aware of the attack. It was the state of
The
Argonia.
moment they came to know, you came to know about the allegations made by them, you were aware.
Your Excellency,
This is a point of attack which you should have assailed the other country
pardon.
for having entered your premises.
Your Excellency, the Shade Fox did not enter our premises. They were,
Through their country, they entered you and spoiled the whole
no,
discrimination.
Your Excellency, it was a cyber attack. It was a cyber attack on our system.
Very much a cause of action to you as well.
Yes, Your Excellency, we came on the awareness of that after the cyber attack happened within few to mention the exact lines.
You sat back. It gives a feeling that you actually relented to it.
Your Excellency, to answer that, can I quote annexure D's lines that don't worry about the higher officials, they are still preoccupied. We are close to completion, but we need the certain. It will slowly dissolves in the court, and no one will know that we have done this. That was after decoding the annexure D. It came to know that they were involved, and slowly they turned the.
We want to know when you were trying to, the people seeking asylum were being differentiated on the basis of they being enemies or they being criminals, they being whatever. Now suddenly your discrimination is, your point for determination is that they are this religion, that religion, this ethnic community. You came to know immediately.
Yes, sir.
Why didn't you assail that? Why didn't you go deeper into it? Why this system is not working? This something is wrong with you. Relented to it.
We went deeper into that, and that's why how we came to know about that the Shade Fox was involved
You
in
didn't
that.
approach us.
Your Excellency,
You didn't approach us.
Your Excellency, that it is like we are in the investigation. We found that the land of Argonia was involved in that. The shade fox was involved. That's why we were in that. Your Excellency, that was majorly the submission that to ensure that to state that the state of Argonia breached our sovereignty. That's why we were incorporating that. The agent was saying that.
But then why did you suspend MIAI?
Your Excellency, we are trying to recode it.
You could have done that. You could have suspended the whole thing absolutely.
Your Excellency, we are identifying that. Your Excellency, to clarify a fact, if the Excellency allows, the entry of the refugees is not being in any way affected by the cyber attack. It is only the deportation process which is being affected. The religion and the basis on which the things were happening. Your Excellency, it is mentioned in the compromise as well that the to quote 6.4 as well, Your Excellency, to show the MIAI was to quote that why didn't we suspended MIAI, to the agent would like to quote page number 15 of the compromise 6.4. Your Excellency, the fourth line, MIAI swiftly tracked and flagged the escapees, leading to their interception and returned them to detention center. MIAI was...
They are your detainees.
Yes, Your
The
Excellency.
migrants that you have detained, they tried to escape.
They did the crime. They did a smuggling of communication devices and external financial assistance. That's why they were detained, Your Excellency. That's why they ran from our detention center, and the MIAI system was perfectly working. We worked upon it. We ensured that the cyber attack was restored and ensured that no such discrimination. We still uphold the policies that of the policy of equality, and at no way we discriminate any of the people from whether it be asylum or any of the citizens as well, Your Excellency. To lastly mention, Your Excellency, the state of Argonia is responsible for the failure to prevent shade fox wrongful and actions, and they have breached the principle of due diligence as well, Your Excellency. The agent would like to mention the Kofu channel case, which state that the states are obliged to prevent their territory from being used from the activities that harms other states or their sovereign functions or any sovereignty of that state. The Tanil Manual 2.0 as well as the United Nations Group of Government Expert Report of recent report of 2021 as well reaffirms that the state must prevent non-state actors from launching cyber operations that disrupt any other state's sovereign function, Your Excellency. Your Excellency.
But then why did you not permit the investigation by the UN Cyber Security and United Nations?
Your Excellency, we uphold the principle of equality. If we would have allowed them, the state of Argonia would have got the right that you are an Union nation. That would be unfair on that part. That's why our president ensured that an independent committee has been established, and that's why they cannot claim that you're on the basis of the independence of the committee, Your Excellency. Your Excellency, the Honorable ICJ has also previously held that the state responsible for the failure to prevent wrongful actions by any non-state actor, despite the fact of whether they had knowledge or not. In the present case, the shade fox was one of the state organ which also performed the elements of the government elements, Your Excellency, and the clear-cut the agent want to mention that the Argonia's liability arises from its failure to regulate shade fox activities and implementing preventive measures against such a cyber threat and originating within their territory and using such an organization to attack on the systems and the sovereignty of another nation. Your Excellency, if Your Excellency are well satisfied with the issue, the agent would like to move on the prayer. Much obliged, Your Excellency. For the reasons stated above, the respondents hereby request the court to declare that the ICJ do not have the jurisdiction. Your Excellencies hold that your court hold that the Numera's deployment of MIAI are within the compliance of international human rights law. Your Excellency declared that there is no breach of international law from the side of Numera on any migration laws or refugee law. Your Excellency find that the Argonia cyber manipulation of MIAI violates the Numera's sovereignty under the international law. And all for this respectfully submitted, Your Excellency. It was an honor pleading before the chamber.
Kindly refer to clarification number 11, Your Excellencies. Clarification 11 is, have both parties consented for the CIA investigation? The answer is yes. No, clarification of the compromise. The compromise. Page 2. Your Excellency is not the problem statement. The compromise. The clarifications. In clarification 11, have both the parties consented for the CIA investigation? The answer is yes. So they themselves consented for the investigation, and now they are pleading before Your Excellency that they don't know where the investigation has come from. If this is not deliberate misleading the court, Your Excellencies, then what is it? Your Excellencies, now page 5 of the written submissions of the respondents. They state that EU has adopted eye border control on their borders. Now they conveniently hide the fact that the same was discontinued in 2019 after 3 years of research trials. The EU Commission has gone on record to say that some research projects are not worth deployment. They conveniently hid this part from Your Excellencies. On page 7, and this was done because there was a huge uproar by the human rights activists because this is causing human rights issues. Now on page 7, blatant fact creation that there was appeals against the MIAI decisions. The compromise is completely silent about any appeals. This is again fact creation just to suit their submissions. Your Excellencies, they say that it was us who said that they are selling the data. Your Excellencies, it is completely clear by the CIA investigation that is not our agency. It is an agency which conducted the investigation by the consent of both the parties. Merely because some findings are against them, now they cannot contend to those investigations. And Your Excellencies, we see how they're playing hot and cold. Now, the only basis of the allegation that Shade Fox was attributable to us in the first place is because of the CIA investigation. That the CIA investigation revealed the location inside Aragonian jurisdiction. So you are accepting one fact which favors you, then you are negating the one fact that is against you.
You admit that it is within your jurisdiction.
It was within the presence was within our jurisdiction. It is not merely attributed to us merely because someone is in our country, Your Excellencies. No other factor has been proven.
But you are an authoritarian country.
No, Your Excellencies, no other format has been proven that we had control.
Draconian acts.
Your Excellencies, pursuant to the sixth rebuttal regarding jurisdiction, all they want us to do, Your Excellencies, is forum hopping. We as a country, we know that under Article 59 of the Charter, your decision is binding upon us. We came to the highest court of jurisdiction in the international matters. We want this dispute to be solved as fast as it can. All they want is to hop from one forum to another. Finally, we will come here only. All they want is to delay the process.
So what do you say about the locus?
Your Excellency,
In fact, they have a good case against you. If we take up their written statement and build up a case against you, cross case.
Your Excellencies, according to the compromise, this court has already framed the issues that are for the deliberation in this instance of adjudication. In that issue, our conduct is nowhere under challenge in the 4 issues that have been mentioned. A separate case can be filed by them, but as Your Excellencies have correctly pointed out, they did not come forward to Your Excellencies, neither in the Shade Fox case nor in the attack case.
Still take up their case.
Yeah, Your Excellencies have the power to do so, but I'll proceed with my rebuttals, Your Excellencies. Your Excellencies, they conveniently mentioned Annexure D. Annexure D is a conversation between theta and zeta. One of the parties is alleged to have been in the jurisdiction of Argonia. They conveniently left the fact that the other person was located in the Numera jurisdiction. So they want the court to believe that the conversation is happening between two people only in the Argonian jurisdiction. Whereas according to Annexure D, the conversation was between one person of Argonia and one person of Numera. They conveniently hit that part.
Are you still on Actio Popularis?
On the part of the locus on the first
Let us know
issue,
what Actio Popularis is. We asked you to verify.
Your Excellencies, due to non-access to any electronic
Because
medium, we
that's
are
right.
not able
The
to.
devices are not with you.
Yes, Your
That's the
Excellencies.
problem.
On that point of law. Your Excellencies, the ninth rebuttal is again a deliberate misrepresentation of fact. They say, we take their word, we take their bona fides that they did not want to conduct an investigation by the CEN because they were a member of the CEN. We take their bona fides that they did not want to be attacked by us in this honorable court, that investigation was a biased investigation. Now, in the same para of the compromise where it is mentioned that CEN came to investigate, it is also mentioned that the United Nations also came in to investigate. Which other forum except that the United States can be an unbiased forum to investigate into their acts, Your Excellencies? The statement of their Prime Minister comes after everything has been done. They have negated the UN coming to investigate. They have not allowed the UN to investigate. Now they say, now after ensuring that everything is spick and span, now they want an independent inquiry. This is very convenient on their part, Your Excellencies. That is all we have to submit in our rebuttal. Thank you so much, Your Excellencies. I would call upon.
You can frame your.
Yes, I would call upon my co-agent to read the prayer. Thank you so much, Your Excellencies.
For the foregoing reasons, in the light of the issues raised, arguments advanced, and authorities cited, the Republic of Argonia respectfully requests the court to adjudge and declare, first, Numera has violated basic international human rights law principle by using the automated MIAI system. We seek the relief that Numera should change the parameters used in MIAI system to take the refugees. Second, Numera has breached the norms and standards for the treatment of refugees and migrants. We seek the relief that give them the recourse of due process and appeal. And the third one, Argonia has not violated the state sovereignty of Numera by any alleged cyber manipulation. And we seek the relief that respondents have to bring certain data records and other records in order to prove the cyber manipulation and the presence of shitbox. Thank you.
Thank you so much, Your Honor. Your Excellency, the Council seeks permission to approach the dais. Your Excellencies, when it comes to
We thought you already asked for your prayer.
Your Excellency,
Generally, when you ask for your prayer, that ends the matter there, right?
we've actually been granted.
That's why we told them you did not see that. We told them not to give us the prayer. We asked them to wait, but you went ahead and gave us your prayers.
Your Excellencies, I bow down to that.
defense is always like that. So many teams. That's what you're right. Not said to do and even not total the case. No, we don't have to judge the team. Are we judging the team or speakers? I think the consultant figures will be the team. So I've just gone by the speakers. That's right. That's what I'm Yes.
I say, dear friends, your excellent performance by all, but few points general, not on the performance of any individual. What is important is the articulation of your argument. How to start your argument, how to proceed with your argument, and how to conclude your arguments. When you are concluding your arguments, you need to highlight the important points once again. The crux of your argument, the main theme of your argument. And then during the course of argument, your voice modulation is very important. Voice modulation is very, very important when you are advancing the argument, right? And another thing, you made good time management, no doubt about it. And another is the proper eye contact with the judges also is very important. Sometimes you lost in your arguments. Sometimes you lost in the counter argument with the judges also. Judges may put any query, but you need to answer. You need to satisfy, but no counter arguments, right? And what is most important, don't and never lose grip over your real issue between the parties. Main issue which was raised by the bench was the locus and the jurisdiction of the ICJ and the violation of human rights, use of MIAI and the cyber attack on the MIAI. These were the important points. Right? So these are the points you need to take care, because the memorials you have prepared, they are voluminous memorials. It's like the written arguments for judges. So very, very difficult to always make it in a bullet point. Make it in a bullet point so that easily we can go through and we can understand your points in controversy. And if some point, if you think is very important, repeat that point again also, so that the judges can understand this is your main line of argument, this is the point which you want to emphasize during the course of your argument. But how to start your argument, how to proceed with your argument, and most important is how to conclude your arguments. Ultimately, the conclusion of your argument would be the best part of your argument. That's why you prepared too much. Prepare what is required and what is to be submitted, because time is limited. Time is 35 minutes plus few minutes. So you need to convey each and every important point of your argument, your case before the bench. Otherwise, you are likely to lose. Otherwise, you are likely to lose, even your case is very strong. All right, but good performance. All of you deserve maximum appreciation and applause from the bench also. It's very unlikely from the bench. After argument, the bench is applauding or appreciating the advocates, right? But thank you, Chair.
We'll do it after the verdict. We announce them.
Now, I would like to request the dignitaries to proceed to the conference room for refreshments.
Sister is asking why not lunch?
Refreshments followed by lunch, Your Lordships.
Madam has the last word.
Yes. Firstly, the students of pharmacy shall proceed for lunch, then the participants, and at last the volunteers. Kindly settle down here only till then. Students, you are requested to settle down in the auditorium until further instructions. Please. Medical? Okay. Pharmacy students may proceed for lunch. Medical students may proceed for lunch. I'm really sorry. अरे वो The students of New Law College are requested to please settle down.
The student.
Students in the balcony can come sit downstairs.
हेलो हेलो ये तो है आवाज व्यवस्थित दिस इज गुड राइट आज who's going to be the you're the one standing up
I want the CRA volunteers please address the dais here down. Courtroom arrangement. Volunteers assisting for courtroom arrangement. Hello. Hello. See, everyone is able to hear me. 1, 2, 3, 4, 5, 6.
मॉनिटरला का नाही ऑन केलंय मॉनिटर का पण ठेवले ते रिपेअर होईल
1, 2, 3, 4, 5, 6. Hello. Hello. 1, 2, 3, 4, 5, 6.
वन टू
अभी पूरा उससे
हा एकच मॉनिटर का चालू ठेवला दोन्ही पाहिजे चालू चालू गेलं कोण बघते साऊंडचं मॉनिटर एक बंद ठेवलाय आपण
backstage committee kindly clear the table. You need the sashes again, no? Clear the table fast.
जैसे पिछली बार लगे थे वैसे ही ना
10 सोफा 5 टिपोए
टेबल
टेबल 3 अंदर 5 के साथ पड़े और 5 बाहर
तो
ऐसे
कांच
ही
का
पड़े
बाद में लाना पड़ेगा
आओ यार
लगा हुआ है नहीं लगा है इसमें 3 में कांच है 3 और बाहर
माइक हटवा दूं
माइक हवा साइड पे रखो कुछ यहाँ
भैया
हेलो हेलो
hello. वक्रतुण्डमहाकाय सूर्यकोटि समप्रभा निर्विघ्नं कुरु मे देवा सर्वकार्येषु सर्वदा
and Argonia. The border crisis.
every development closely.
All the participants are kindly requested to proceed towards the food area. Only participants, not the volunteers. I repeat, only the participants are requested, not the ushers.
गुड आफ्टरनून. आवाज आ रहा है?
एक चेयर ये उठा दो.
Good afternoon, everyone.
गुड आफ्टरनून एवरीवन. हाँ ठीक है, ये डिस्टेंस हो गया है. हाँ. सर ठीक है, और इतना सर है ना. गुड आफ्टरनून. तो ठीक है ना, अभी क्या दूसरे में सक्सेस. हाँ ठीक है. गुड आफ्टरनून एवरीवन. ठीक है.
हेलो हेलो 1 2 3. हेलो हेलो 1 2 3. हेलो हेलो हेलो. Hello. Hello. Hello.
अबे तुम क्यों तेज बोल रहे हो? तुम नॉर्मली बोलो ना.
Hello. 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 One, two, three. 1, 2, 3. 1, 2, 3. Hello.
हाँ ये ठीक है, ये नहीं ठीक है.
अच्छा मेरे
Hello. All the volunteers are requested to proceed for lunch.
Hello. ठीक. Hello. Hello. ठीक. Hello. 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 ठीक. Hello. Hello. Mic check. One. Check. Hello. Hello.
की माझ्याकडनं नव्हतं कारण आर्थिंग जर झाली असती ना डायरेक्ट ट्रिप मारली असती मशीन आर्थिंग शॉर्ट असतं आर्थिंग असते भेटले तर एक्सिबिट तिथं Check. Hello. 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 Check. One. Check. Hello. Hello. Check. One. Check. Hello. 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 Check. Hello. Hello. Check. One. Check. Hello.
Journalists trying to cover the crisis.
Hello. 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 Check. Hello. 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 Hello.
पोडियमचं नको ते आपल्याला.
असा ॲडजस्ट केला तर असा असा ॲडजस्ट केला तर हॅलो चेक 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 नाही ना
नको तो पोडियमचं नको.
मग हे काढून टाकू
खाली ठेवून देऊ आपण. ते वापरणार तरी त्याला ऑफ करून टाकू. थांबा, त्याला बटन आहे ना ऑफचं.
ऑफचा विषय नाही आहे. हा काढून इथं ठेवला ना मग ते इन्स्टा मार्क देतील ना. तो तिथे ठेवला तर ते चालूच करणार.
ऑफ केलंय ना.
ऑफ काही काय वायरच काढली ना.
हां बरोबर.
हॅलो हॅलो चेक चेक 1 1 हॅलो चेक 1 2 3 ओके.
हा ठेवू.
हां इथंच ठेवूयात म्हणजे कसं लोड नाही राहणार आहे. बट भैया दिक्कत हो रही है उनको.
आपको चाहिए तो ले लो.
पता है यहाँ दो लोग खड़े होंगे तो वो ऐसे ऐसे बार बार एक्सचेंज करना.
तो दोनों के पास माइक देते हैं ना ये.
दो माइक है. दूसरा है जब एंकरिंग का काम हो जाएगा तब उनको दे देना माइक जजेस को.
हाँ ऐसे करते हैं. अभी यहाँ पे बोल लेते हैं एक्सचेंज करके.
हाँ एक्सचेंज कर लो क्योंकि
requested to please put their phones on silent.
This afternoon, we gather to celebrate the culmination of an incredible journey, one that has been marked by intellectual rigor, unwavering dedication, and a profound passion for law. Over the past few days, we have witnessed exemplary legal arguments, in-depth research, and remarkable advocacy skills that have set new benchmarks in the realm of mooting.
Participants from diverse backgrounds and legal traditions came together to engage in thoughtful discourse and showcase their expertise. Each argument presented and every submission made reflected not only their legal acumen but also a deep commitment to justice and fairness. This competition has truly served as a melting pot of ideas and a celebration of the legal fraternity's unity and diversity.
As we honor the achievements of our talented participants, let us also reaffirm our dedication to the ideals of justice and the rule of law. The knowledge and experiences gained here will undoubtedly serve as a beacon as we move forward in our respective legal journeys. In our Indian culture, it is customary to seek divine blessings before embarking on any auspicious endeavor. As we bring this remarkable 3-day event to a close, we wish to express our heartfelt gratitude through the art of dance.
I'm excited to invite a gifted artist who seamlessly blends her passion for art and law. Let us warmly welcome a Kathak graduate and a final year law student from New Law College, Pune. With her grace and skill, she will deliver a mesmerizing performance that pays tribute to the divine forces that have guided us through this journey. Please give a big round of applause for Ms. Utkarsha Gupte as she takes the stage.
वक्रतुण्ड महाकाय सूर्यकोटि समप्रभा निर्विघ्नं कुरु मे देवा सर्वकार्येषु सर्वदा
हे गजवदन हे गजवदन वक्रतुण्ड महाकाय हे गजवदन वक्रतुण्ड महाकाय
वक्रतुण्ड महाकाय अवतारी आम्ही धरितो तुमचे पाय अवतारी आम्ही धरितो तुमचे पाय हे
गजवदन वक्रतुण्ड महाकाय हे गजवदन वक्रतुण्ड महाकाय हे गजवदन वक्रतुण्ड महाकाय वक्रतुण्ड महाकाय वक्रतुण्ड महाकाय सकर्ता तुकारता माता विघ्नाची पूर्वी प्रेम कृपा जयोची सर्वांगी सुंदर सिंदुराची कंठी झळके माळ मुक्ता फळाची जय देव 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 रत्नाखचितांबरा तुझगौरी पुरा चंदनाची उडी कुंकुम केशरा हिरे जडित मुकुट शोभतो बारा कुंकुडती तुंबुर चरणी आगरिया जय देव 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 जय देव
लंबोदर कृष्ण विघ्नेश्वर कृष्ण देवी
तभी तो तुम्हा संकट हमसे विलया लागा
तभी तो तुम्हा संकट मुझसे विलया जाओ
तभी तो तुम्हा संकट हमसे विलया जाओ हे गजवदन वक्रतुंड महाकाय हे गजवदन वक्रतुंड महाकाय वक्रतुंड महाकाय वक्रतुंड महाकाय लंबोदर पीतांबर भैरव वंदना सरसुंदर वक्रतुंड त्रिनयना वासा वक्ता सुंदर सुंदरी भावे धीमहि रक्षावे सुरवर वंदना जय देव जय मंगलमूर्ति दर्शन मात्रे तुझे जय देव जय मंगलमूर्ति दर्शन मात्रे मन तुझे जय देव 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 जय देव
Thank you, Utkarsha, for that mesmerizing performance. Before we move on to the awards and recognitions, let us take a moment to extend our sincere gratitude to the patrons and distinguished guests who have honored us with their presence.
The organizing committee has poured its heart and soul into creating a documentary based on the Moot compromise, which was passionately argued and presented by the participants. It would be an honor for us to showcase this documentary to our esteemed judges.
I request Arundhati to please play the documentary.
Good evening and welcome to Pulse Point News. I'm Emma Sterling.
And I am Naira Kesil. Tonight, we turn our focus to the brewing humanitarian catastrophe at the Numeria-Elgonia border. Emma, it seems that both the nations are locked in a ruthless game of geopolitical chess.
Absolutely, Naira. What was initially presented as Argonia's open doors policy in 2022 has now been exposed as a high-stakes maneuver funneling desperate migrants towards Numera, dangling false promises of asylum and prosperity.
Numera, well, they were not exactly rolling out the red carpet either. In response, they forfeited their borders, leaving migrants stranded in a makeshift camps. And let's not forget, journalists trying to cover the crisis, detained. Emma, I ask you, has Numera lost its sovereignty?
That's the million-dollar question, Naira, and the world is watching. Human rights groups argue that Numera is violating international refugee laws, while the government insists it's safeguarding national security.
And speaking of division, the international community is just as split. Meanwhile, the ESHRC is receiving complaint. But one thing is certain, human cost is undeniable.
It's a geopolitical tug of war, Naira. And let's be real. This isn't just a border crisis. It is a crisis of conscience. We'll be following every development closely and would love to hear your thoughts. Tweet us at Pulse Point News.
That's it for tonight. Stay safe, stay informed. Good night.
If the West wants to punish us with sanctions, we will flood their borders with refugees. Let them deal with the chaos they have made. This is not a choice.
Argonia has accused Numera of engaging in state-sponsored violence against migrants at the border. How do you justify this use of force?
Well, let's address the fact and not the propaganda. Argonian forces deliberately escorted migrants towards our border, ignoring all diplomatic channels. Numera security personnel acted well within the bounds of international law. And we regret any loss of life, but we will not apologize for protecting our sovereignty.
Ma'am, with mounting evidence of Numera's government officials allegedly facilitating the unauthorized data trade, international bodies like the UN have launched formal investigations. Will your government cooperate?
Well, we do welcome transparency, but we do not welcome any politically motivated probe masquerading as justice. Numera has always complied with the international law, but we will not participate in any witch hunt instigated by those who stand to gain from destabilizing our government. Any formal investigation must be impartial and not a pre-written script looking for actors.
Ma'am, MIAI has been accused of tracking individuals beyond your borders. Some say this is a form of AI-driven oppression. How do you respond?
Ah, the big brother argument. How convenient. Every major nation deploys AI for security, governance, and intelligence. When they do it, it's innovation. And when we do it, it's oppression.
Argonia did not create MIAI's fraud system or profit from the vulnerable migrants' data. The question here is not who exposed the truth, but why the truth was exposed in the first place. Numera claims to follow sovereignty, but secretly spies on people beyond its borders. Numera should focus on leading with honesty and not exploiting others.
Hello, and welcome to Global View News. I am Heather Khan. Our studio has just received an update. Tension simmered between Numera and Argonia. The border crisis threatens to destabilize the heart of US. With USD watching closely, fears of regional spillover loom large, especially when the ongoing conflict between Rice and Ukraine, marked by territorial dispute, has sent shockwaves across the continent. The MIAI human rights battle has truly ignited a fierce debate where Sandoria is advocating for strict ethical frameworks. Veskila pushes for AI autonomy. The world now turns its gaze to The Hague, where the ICJ is set to deliver its landmark ruling on 22nd of March. Will this be a turning point for peace or a spark that reshapes Euris forever? Stay tuned with us for the exclusive update.
Thank you, Arundhati. Now, I respectfully invite the dignitaries to please grace the stage. Today, it is our esteemed privilege to welcome Honorable Justice Ujjwal Bhuyan from the Honorable Supreme Court of India as the chief guest for the closing ceremony of the 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights. We express our heartfelt gratitude to your Lordship for graciously accepting our invitation and gracing us with your esteemed presence.
Honorable Mr. Justice Ujjwal Bhuyan, a distinguished jurist of the Supreme Court of India, brings a wealth of legal expertise. An alumnus of Kirori Mal College, Delhi, he pursued his LLB from Government Law College, Guwahati, and LLM from Guwahati University. With an illustrious career at the Guwahati High Court, he served as a standing counsel for the Income Tax Department for 16 years and held key positions such as Additional Government Advocate for Meghalaya and Special Counsel for Arunachal Pradesh.
Your Lordship was appointed as an additional judge of the Guwahati High Court in 2013. He was later transferred to the Bombay High Court and took oath as a judge in 2019. Justice was elevated to the Honorable Supreme Court in 2023. He continues to contribute to legal education as a member of the General and Executive Councils of the NLSIU Bangalore and the General Council of Maharashtra National Law University, Aurangabad. I now kindly request Mr. G. Jayakumar Sir, Registrar, Bharati Vidyapeeth deemed to be University, to present a token of felicitation to your Lordship. Thank you, your Lordship. Thank you, sir.
Honorable Mr. Justice R.M.S. Rajakaruna, a distinguished Sri Lankan jurist serving as a judge at the Supreme Court of Sri Lanka. Justice Rajakaruna is an alumnus of Nalanda College, Colombo. He pursued higher education at the University of Colombo and Sri Lanka Law College, furthering his legal studies at the National University of Singapore. Before joining the judiciary, he held the position of Senior Deputy Solicitor General in the Attorney General's Department.
Your Lordship began his judicial career as a judge of the Court of Appeal of Sri Lanka in 2020. In 2024, he served as the acting president of the Court of Appeal. His exemplary service led to his elevation to the Honorable Supreme Court of Sri Lanka. Justice Rajakaruna's career reflects a steadfast commitment to upholding justice and contributing to the development of Sri Lanka's legal system. I now kindly request Jayakumar Sir to present a token of felicitation to your Lordship. Thank you, your Lordship. Thank you, sir.
Honorable Mr. Justice Devan Ramachandran from High Court of Kerala. Your Lordship obtained his law degree from Maharaja's Government Law College, Ernakulam. He commenced his practice under the guidance of his father, Mr. M.P.R. Nair, a barrister in law from Middle Temple, London, and a senior advocate. With a focus on constitutional law, company and corporate matters, banking, and other financial and commercial laws, he built a stellar independent practice.
Recognizing his exceptional expertise, the High Court of Kerala designated him as a senior advocate on 21st of November 2015. His dedication and legal acumen led to his swearing in as the additional judge of the High Court of Kerala in October 2016 and his subsequent appointment as a permanent judge on 16th of March 2018. I now kindly request G. Jayakumar Sir to present a token of felicitation to your Lordship. Thank you, your Lordship. Thank you, sir.
Honorable Mr. Justice Siddharth Verma, a distinguished judge at the High Court of Allahabad. Justice Verma completed his law degree from Allahabad University in 1992 and enrolled as an advocate on February 5, 1992, primarily practicing civil law. His judicial journey saw him elevated as an additional judge of Allahabad High Court on November 2016 and later appointed as a permanent judge in March 2018.
Throughout his legal tenure, Justice Verma has contributed to several significant rulings, including those related to the SC/ST Act proceedings and the Zamindari Abolition Act. I now kindly request Ms. Ujjwala Pendale ma'am, Dean and Principal, New Law College, Pune, to kindly present a token of felicitation to your Lordship. Thank you, Your Lordship. Thank you, ma'am.
Honorable Miss Justice Neena Bansan Krishna, Your Ladyship did her LLB from Campus Law Center and LLM from Faculty of Law, Delhi University. She joined Delhi Judicial Service as a civil judge in the year 1992 and was promoted to Delhi Higher Judicial Service in 2002. Your Ladyship has dealt with cases of various natures, including money laundering, terrorist and disruptive activities prevention act, prevention of terrorism act, protection of children against sexual offense act, and etc.
She was presenting officer in the National Human Rights Commission, New Delhi from 2005 to 2006. She is a trained mediator and a master trainer with the Mediation and Conciliation Project Committee, Supreme Court of India. Having taken her training from CETR UK in 2007, she has held the post of director in Delhi Judicial Academy since February 2017 till May 2019. I now kindly request Dr. Ujjwala Pendale ma'am to present a token of felicitation to your ladyship. Thank you, Your Lordship. Thank you, ma'am.
Honorable Dr. Justice Sudhir Kumar Jain, a distinguished jurist who served as a judge at the High Court of Delhi until his retirement on November 2024. Your Lordship pursued his legal education at the Faculty of Law, University of Delhi, where he obtained his LLM, LLB, and PhD degrees. He began his legal practice in the Delhi District Courts and the High Court of Delhi. He also served as a lecturer at the Campus Law Center, University of Delhi, before joining the Delhi's Judicial Services in 1992. In 2022, he was elevated as a permanent judge of the Delhi High Court.
A trained mediator for over 15 years, Honorable Mr. Justice Sudhir Kumar Jain conducted mediation in approximately 12,000 cases. He also served as the in charge of the Delhi Mediation Center for over 6 years and conducted more than 100 training programs on mediation across India for judicial officers, advocates, and law students. I now kindly request Dr. Ujjwala Pendale ma'am to present a token of felicitation to your Lord. I kindly request Dr. Dharma ma'am to please present a token of felicitation to your Lordship. Thank you, Your Lordship.
I now kindly request Dr. Ujjwala Pendale ma'am to present a token of felicitation to G. Jayakumar sir. Thank you, ma'am. Thank you, sir.
Now, I kindly request G. Jayakumar sir to kindly present a token of felicitation to Hemant sir, President Bar Council of Pune.
Thank you, sir. Today, we are truly honored to have experienced the wisdom and insight of a distinguished panel of 5 esteemed jurists from across the globe who graced the final rounds with their presence. Their invaluable guidance, unwavering support, and remarkable patience have left an indelible mark on this competition.
We are profoundly grateful for their dedication in meticulously analyzing every argument presented and for the commitment to nurturing the next generation of legal minds. Witnessing such revered professionals engaging in thoughtful discourse with our budding lawyers and generously sharing their expertise has been an inspiring and enriching experience for us all. We would now like to invite Honorable Justice R.M.S. Raja Karuna to please grace the stage with his wise words.
His Lordship Ujjal Boyan Janja, the Supreme Court of India, and the other honorable judges, High Court, honorable judges of the High Court, the distinguished Chancellor, the Vice Chancellor, and the Dean, and the faculty members, and also the distinguished registrar of this university, and the distinguished guests and other dignitaries, students. I'm deeply honored to have been invited to judge in the morning, preside over and deliver and talk to you at the Bhagwati International Moot Court Competition in Pune, in India. I take this opportunity to extend my heartfelt gratitude to the Dean, the convener, and the organizing committee of the Moot Court Competition, and the students of the Bharati Vidyapith New Law College, a cradle of legal scholarship and advocacy, for extending an invitation and offering their warm hospitality during my short stay in India. India is close to my heart for various reasons. One such special reason is that Bodh Gaya is situated in Gaya district, where the Lord Buddha attained enlightenment. I must acknowledge the hard work of the participants, especially those who have toiled to make it to the final rounds, which I was able to judge along with my brother judges of the High Court, justices of the High Court of India. The arguments articulated by the participants during their submissions in the final round certainly did display most of the skills needed by practicing counsel, and I can assure these young individuals that they would undoubtedly make a remarkable and illustrious legal career in the near future. I wish them very best of luck in all their future endeavors. Organizing moot court competitions at law schools can be considered as a cornerstone of legal education, which offers law students an invaluable opportunity to bridge theoretical knowledge with practical application. These mock court proceedings will help law students cultivate the skills in advocacy and rich traditions prevailing in the legal system, especially inside the courtroom. You will develop the skill of challenging your opposing counsel arguments from a unique angle, strictly but politely. Mahatma Gandhi has once advocated to be like lawyers, as they forget everything the moment they come out of the courtroom. Eventually, moot court competitions foster a deeper understanding not only of procedural aspects but also of the ethical dimensions enriched with rich legal traditions. It is interesting to note that the theme of this moot court competition is combined with the AI and fundamental rights. AI has emerged as a transformative force reshaping industries, governance, and daily life with incredible speed and scale. Its capability to analyze extensive data, forecast results, and streamline decision making offers significant potential to advance human rights while concurrently presenting serious dangers that jeopardize those same rights. Bridging privacy, equality, freedom of speech, and access to justice, AI's twofold character as both an enabler of progress and possible source of suppression demands a delicate examination. Artificial intelligence isn't a physical item you stumble upon in a box, basket, or container, nor is it a consumable like food or drink. Instead, AI resides within an electronic devices such as laptops, can be in phones, tablets, existing outside our bodies as a digital construct. Yet through these devices, AI can metaphorically be absorbed into our minds and lives as we interact with its outputs, learn from its insights, or adapt to its influence at our choice. Far from being a tangible substance, AI is an internal technological entity that we engage with, shaping our thoughts and actions through the tools we choose to wield. On the other hand, your friend, your neighbor, or the political opponent may wield AI, causing prejudice to your rights. In such an event, the aggrieved person will have to recourse to a court of law for compensation or to get a possible or to get punishment imposed against the wrongdoer. In my opinion, AI becomes dangerous not by its simple existence, but by how we make it relevant to our rights and facts in issue. Its ability to configure privacy, equality, and justice, whether through surveillance, biased algorithms, or unclear evidence, turns relevance into a conduit for a harm when unchecked. However, through strict supervision and principled or ethical development, we can steer AI's impact towards empowerment, guaranteeing its strengths rather than its weakness as a foundation of human rights. The decisions rest with us. Shape AI into a protector of fairness or allow it to evolve into a danger we regret. Artificial intelligence stands at a cornerstone of a crossroad for human rights, offering a new era of protection while teetering on the edge of peril. Its ability to enhance equality, justice, and welfare needs to be matched its capacity to erode privacy, fairness, and autonomy if left unchecked. AI danger tied to its relevance is not inevitable, but I believe that it can be tamed through good conscience and good governance. Legal systems must impose transparency as urged by Bangalore Principles, diligence mandate, ensuring AI's outputs align with evidence standards like those in evidence ordinance. When AI intersects with human rights or judicial proceedings, its relevance to these critical areas can amplify its capacity to harm, turning a tool of progress into peril that undermines privacy, equality, due process, and justice. AI will not become dangerous precisely through the ways it is tailored to impact our rights and the determination of facts until and unless we decide to use it for our personal benefit, violating the basics of good governance and good conscience. So, is AI a new era of protection or peril? The answer lies in our hands as jurists, lawmakers, and future advocates like yourselves. We must craft legal frameworks that embed accountability into AI systems, mandating transparency and human oversight, much like the constitutional checks we uphold. AI has a potential to be our partner in the endeavor, but its success depends on our prudent use, guaranteeing it enhances human rights instead of jeopardizing them. As law students, your task is to innovate legal vaccines to shield the rights of individuals who integrate AI's productivity into their personal experience. While computer technologists and experts must develop advanced software antibiotics to evaluate and verify authenticity, protect patent rights, and uphold human dignity with AI's domain. Together, these efforts can steer AI towards empowerment, balancing its promise with the preservation of justice and humanity. So with that note, I once again take this opportunity to thank the organizers for inviting me, and once again, please accept my heartiest congratulations for the students who participated today and right throughout last 2 days or whatever the long process, hard work, congratulations. And I wish all of you good luck, good success in all your
Thank you so much, Your Lordship. Indeed, it was really insightful. Your Lordship taught us the best lesson that how AI in this modern era is dangerous, but on the other hand, we as law students have to make a responsibility that we need a responsible AI. With this, now I would like to invite Honorable Justice Mr. Devan Ramchandran, Judge, High Court of Kerala, to enlighten the gathering by his rich experience in the legal domain. Please, sir.
I suppose in 1991 when I was sworn in, when I enrolled. If I tell you that today, would you say that that is progress? You would say that is complete stagnation. But if I'm able to tell you that I am a better version of myself today than I was yesterday, that is progress. For that, you require a continuous evolution. And this is where moot courts come into play. I was also a mooter. For all the 5 years of my student life in the law colleges, I was traveling up and down. I never won a moot court, but I won the experience. One more thing. If you remember the way we were grilling you, it is not because you were bad, it is because you were very good. Now, we showed you that the problems could be looked at and analyzed in different methods. And this is a big lesson that you take away from a moot court. You look at a problem once, you get a solution. You look at the problem again, you get a second solution. You look at a problem third time, you get a third solution. Believe me, you look at it 12 times, you get 12 solutions. Now, all those solutions may be, opposite in the given circumstances. But why do we think that a particular lawyer is better than the others? How do we say that in a bar? We have a leader of the bar, and why do you call them a doyen or a cut above the rest? It's very simple. It is not that they have a better intellect or that they are intellectually more capable. We are all equal. Our cerebral space is the same. Our capacity is the same. It is just that among the alternate solutions that you can look at for the problem, that if you can choose which is most feasible, most efficacious, most expedient for your client, you are a better lawyer than the other. In every solution, you will have a junction facing you. You can move forward, you can take a reverse, you can go to the left, you can go to the right. It depends on which direction you want to take. I can come to Pune in many words, right? I can fly direct from Kochi, I can fly to Hyderabad or Bangalore or whatever. They're all the same. We are reaching the destination. But where I choose that alternative which is the most efficacious for the client, there you become a better lawyer than the other. And this, my dear young friends, is what the profession is all about. One more thing about the profession. Profession is nothing but reputation. However good you are, however prepared you are, however educated you are, if the community doesn't think you are a good lawyer, you are not a good lawyer. Alternatively, however mediocre you are, however unprepared you may be, if the community thinks you are a good lawyer, you are a good lawyer. But hold your horses, the second never happens. Therefore, what you are now doing as students is the beginning of a continuous quest for finding the best version of yourself through continuous evolution, betterment, and honing of skills. This is what moot court can really do to you. It doesn't matter whether you win. It is better that you lose, because you must also learn to, accept failure, which is what you will do as a lawyer. Ask all the senior lawyers, all the judges who are sitting here. We have lost more cases than we have won. It's simple, because as you grow, in stature in the profession, who will come to you paying your fee for a good case? They'll come to you for a bad case. And it depends on you to salvage it to the extent you can. But eventually, you may not win every one of them. So failure, acceptance of failure is very, very important. That you learn at the moot court. Those who failed today, congratulations. Those who won today, God be with you. I hope that one day you will all be sitting here, judging the next generation and speaking to them sense, not the nonsense that I'm speaking, but sense to them. Give them that, the courage and the direction to go forward in future. I would have spoken longer, but I've been told not to. And I believe that if I have a, you could have mentioned the time in front of me, 5 minutes, 2 minutes, 1 minute and all that. Since that has not been done, no. Since that has not been done, this is all that what I want to tell you in the most concise of words. And I'm speaking fast because I don't want to take away time from my other panelists. But you have done very, very well today. Believe me. Whether you win or lose, you will possibly win or lose by a margin of a few or maybe a couple of marks, nothing more. Very difficult for me to choose the best between you. I did not total the marks because I don't think that any one of you did, less better than the other. You did remarkably well. One word for those eminent gentlemen and ladies who made that problem, What kind of a problem is this? This is a problem that can confuse the best of the minds. If Justice Bhagwati had been here today, he would have run. And what are we? Thank you very much for the opportunity. We hope to see you as great lawyers. And those who are going to enroll in the next 1 or 2 years, come to Kerala, court number 5A. I sit there. Thank you.
Hello. Hello. Yeah. So the words were really charismatic and energetic. Thank you so much, sir, to waken up the audience in such a sleepy afternoon. So as you know, as sir said, the best lesson and the best advice he gave, the two key takeaways is focus and experience, because public perception you cannot never change. Okay. So now I would like to invite Honorable Mr. Justice Siddharth Verma, Judge, High Court of Allahabad, to grace the podium and the dais for the hearing.
Respected Chief Guest, sir, Justice Bhuyan, our brothers and sister judges of the High Court, Justice of the Supreme Court of Sri Lanka, my dear students, ladies and gentlemen. When I got the invite from this university, I thought that I was invited to speak on a subject which was very close to my heart. But when I started to delve into it, I realized I didn't know much about it. In fact, I knew nothing about it, except that when I wrote an SMS and autocorrects, I thought it was artificial intelligence which does it. And I thought that it's a very great thing which happens. And in fact, it is also very irritating when it corrects it in the wrong manner. But I could lay my hand on a book called Life 3. It is by Max Tegmark, and Being Human in the Age of Artificial Intelligence is the book written. The book which he has written is titled in this manner. And then it is Life 3. He goes about to tell how Life 1 we've lived, Life 2 we are living, and then how we will enter into Life 3. And just as Justice Ramachandran said, that the young gentleman who had come up with the topic had confused us all, the book also confused me a lot. It was nothing that I could catch in the first reading, but actually, when the topic came and I had to go through it in a more pointed manner, I could feel that I could understand more of the book and more of the subject. There are a few questions which he asks in the book. He starts with this in his book, Being Human in the Age of Artificial Intelligence, Life 3, Max Tegmark writes, "That is why I wrote this book. I wrote it in the hope that you, my dear reader, will join this conversation. What sort of future do you want? Should we develop lethal autonomous weapons? What would you like to happen with job automation? What career advice would you give to today's kids? Do you prefer new jobs replacing the old ones, or a jobless society where everyone enjoys a life of leisure and machine-produced wealth? Further down the road, would you like us to create Life 3 and spread it across our cosmos? Will we control our intelligent machines, or will they control us? Will intelligent machines replace us, coexist with us, or merge with us? What will it mean to be human in the age of artificial intelligence? What would you like it to mean, and how can we make the future be that way?" Are these the questions which arise in our minds also Definitely, yes. These questions were very confusingly coming up in my mind all the time. Whenever we get across a problem concerned with artificial intelligence, these are the questions which erupt in our minds. And these have been very succinctly and nicely put in this book. And then he goes on to answer each question separately and in a very professional manner. He goes on to even inform us that how an age would come when there would be no producers, no directors, no actors, and yet there would be a film. He goes on to tell us that how there would be no law courts, no lawyers, no judges, but there would be still judgments. Then he comes up with so many other problems which are there in the book and which would be very pertinent for all students who are here, whether they are interested in AI or not, whether they have come across any problem of AI or not. They would all have to face these problems. But one very important and the saving grace is that just as we have been able to control so many things through our laws, just as when the first time when a cloth was invented, we were as human beings very worried how this cloth would be converted into wearable clothes. Then we thought how they would be sold, how they would be marketed, how the export-import would take place. But fortunately, we as lawyers know that law can manage everything, and we did manage it all. Then we came with the problem of industrial revolution. We thought that industrial revolution is now going to make everything redundant. All human beings would become redundant. When the ghoda gadis go, the cars would take over. When the aeroplanes come, this would go, that would go. But we see that everything has come up in a very balanced manner. Similarly, things happened when the typewriter came. My grandfather used to say that when the typewriter came, his father used to say that all stenos and everybody would go waste, everybody would start typing. But we as human beings, we can manage everything, we can balance everything very well. And similarly, when computers came, there was a lot of resentment, not only in our country, in also very developed countries, that the computers would now take over everything and everything would go to the dogs. But without computers, we can't do anything now. And computers are very great friends of ours, and they are also making us lazy or whatever. But the point is that laws are there. We came up with IT, information technology laws. Now is the time when we have to very stealthily move towards the era where we can control this artificial intelligence, and we have to preempt everything. If we leave it on fate, we might it might lead us all to a stage where artificial intelligence would actually conquer us. You must all be, when you are privately discussing artificial intelligence, you all must be discussing how a day would come when, as this book says, judgments would be there without the courtrooms, medicine would be there without the doctors, etc., etc. But we all know that law would be there, and legislation would be there. Legislation would bring out laws, and we would be the winners. It would be a win-win situation. You have many other speakers to listen to, and this is the only advice and the positive aspect of it which I would like to say, that don't worry, the law is the legislature is there, law would take care of everything. Thank you so much. And I would, in the end, like to thank the organization here, and especially the students who had invited me. There's the next student sitting over here who's a lawyer in Allahabad. She was also responsible for actually asking me to come over here. Thank you so much. Pratik Sharai.
Thank you so much, sir, for your powerful words. I would like to give you an example. how sir said that, technology and AI has conquered upon us. When sir told me the name of the book when he was addressing the gathering, I was at the back, Googling it. What is the book all about? I read the 3 stages we talk about: biological evolution, technological, and, social evolution. Do anyone recognize what I did? I never thought like how many pages is the book? Is it very lengthy? The English, the vocabulary involved. I straight away went to technology. I just wanted to find what is the summary. I never thought of reading the whole book. That is how dangerous AI is. So thank you so much, sir, for letting us know. Now, I would like to invite Honorable Ms. Justice Neena Bansal Krishna, Judge, High Court of Delhi. Please, ma'am.
Honorable Mr. Justice Bhuyan, all the dignitaries and my brother judges on the dais, and of course our most important members, that is the students, and all those who are present in the gallery. We would also, I would like to acknowledge our Bar President and the Secretary, who play a very important role in supporting young lawyers and also are responsible for the atmosphere that gets created in the bar. And to be able to forge a balance between the bar and the bench, I think is very important. And I'll just begin by saying, because I've started from there, that you as young lawyers, when you join the profession, please look up to the president and secretary. I'm sure they'll help them and they'll guide them the best way. Having said that, I would like to just honestly confess that I'm a wild card entry. I I was invited at the last minute. So my speech is also going to be as wild as my entry is. This moot court, when I was sitting here, and a few other programs where I've attended, I go back to my time when we never had this kind of a moot court which was mandatory. It was only an optional exercise where some would participate. For us, it never attached any importance, but as has been highlighted by my earlier speakers, moot court is the actual learning in the faculty. You pick up the confidence, which is most important, firstly, to be able to stand and to know how you have to address. Yesterday also I was talking to our young students. Knowledge you would acquire. See, the expertise you would gain with experience, with period, with passage of time. But what is most important for all of you is to understand the nuances of how to present yourself firstly in the court. The way you conduct yourself is the starting point. And here, what personally, especially after coming to the High Court, I have understood is that the way your communication skills are very important. The other thing which I've always felt is that when you are standing on the other side, you must first learn the knack of reading the judge. If you understand the personality and the way the judge looks at things, half of your battle would be won. So what is important is communications, your rapport building, your knowledge. And the next important thing is always be open. Open to correction, open to learning, and pick it up from everywhere and anywhere. Knowledge is not confined only to the books or to our computers, it is everywhere. When you read people around, you would learn a lot more. I would just say a few things about this AI. All of us, as was being discussed, in our times, we would always go to the digests to the libraries. We all had an habit of looking into the material. And when you open a book, you are not confined only to what is there in front of you, but you also pick up lot many things which are there on that page, and therefore you get a better vision into the problem or the knowledge. What is happening now, and I have my law researchers with whom I'm always fighting, because they've got into this habit of doing a word search, not even the section, not even the law. They don't like to go even to the Manupatras and they are not doing it. What they do is they do a word search, they read 2 lines. Many a times you get articles. That is not the right way. What is happening is we are becoming spoon-fed. We read a thing and that is killing our own ingenuity in interpretation and learning and thinking. My only request to all of you is don't get so limited by this convenience of computers, the AI as we are terming. I have seen there were these interns who came to me and they were quite insistent that we are very keen to work for you. You please tell us something to do. So I said, all right, this is one topic on reputation, defamation. Please get me an article on this. Lo and behold, 5 minutes, and there was a beautiful 10-page article. And I just blinked. I said, from where did it come? And the honest confession was, Chat GPT is our remedy to every difficulty. Please don't do it. It will help you. It will give you instant solutions. But the problem is you will not grow in your mind. So don't kill your own independent thinking. Rely. They do give you some material, but don't stop questioning and traveling beyond what is there presented by our computers to us. In the end, I would only say that all of you were brilliant. And while the way you all participated and you were able to handle the 5 ICJ judges was, I think, tremendous. And this can only, it makes me happy to say that we have young minds who are very inquisitive, and definitely sky's the limit. You all need to just target and have an high aspiration. All of you will succeed. Thank you so much.
Thank you so much, ma'am, for such powerful, and insightful experience given, like how the relationship between bar and bench needs to be exercised, needs to be learned through this moot court competition. And of course, you should not lose your dependence. You should read articles and not just do keyword search on SCC Onlines in your internship. So better be careful. So now, thank you so much, ma'am. Now I would like to invite Honorable Dr. Justice Sudhir Kumar Jain, retired judge from Delhi High Court. Please, sir.
Honorable Mr. Justice Ujjal Bhuyan, Judge Supreme Court of India. Honorable Mr. Justice RMS Raja Karuna, Judge Supreme Court of Sri Lanka. My esteemed and respected brother judges from different high courts, registrar, faculty, students, and participants of this moot court competition from India and abroad, other guests and ladies and gentlemen, and the member of the Bar Council of Pune, and good afternoon to all of you. I am extremely thankful to the organizer of 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights for conferring this honor on me to be the part of this valedictory program, and also gave me an opportunity to be a judge in the final round of the moot court competition. I also take the opportunity to congratulate participants and winners of the 30th Justice P.N. Bhagwati International Moot Court Competition on Human Rights. The participating teams belong to prestigious colleges and university at national and international level. This is an outstanding achievement for organizer of this competition and reflect the popularity of this competition. The organizers of this competition deserves every possible appreciation and applaud. In the morning, we all witnessed the final round of the problem, which was basically a conflict between the human rights and artificial intelligence. The way the arguments were put forward, the way the memorials were prepared, the young the young student, they prepared themselves to present the arguments before the judges. It was really a remarkable, very delighting things to watch from the podium. I can say the future of the legal education, the future of the legal field is in the safe hands. After watching the performance, today we have witnessed a very good problem, the conflict between human rights and the use of artificial intelligence. Dear friends, the human rights are the universal and inalienable rights that every human being possesses regardless of race, gender, religion, nationality, or any other status. The artificial intelligence in the present time is invading and affecting every aspect of the human life, such as from healthcare to education, governance, and justice. AI has the potential to affect nearly every recognized human right, including the right to freedom of expression, thought, assembly, association, movement, the right to privacy and data protection, the right to health, education, work, and non-discrimination and equality under national and international law. And these rights and other rights within the increased use of AI has been abused and violated. As we have witnessed in the morning, AI, like any other technology, carries inherent biases and ethical consideration, and its application can either uplift or undermine human rights. AI can be used as a boost to human rights protection or as an accelerator of human rights violation. The human rights must be protected in digital age of development and implementation of artificial intelligence. AI application and tools do have a significant impact on human rights, and recent year has attracted considerable attention of the political institution, academia, and civil society toward the risks caused by the AI application. Although AI provides vast opportunity for improving human rights, but its rapid advancement also raises concern about privacy, discrimination, and ethical governance. AI may play a crucial and vital role in the protection and promotion of human rights. It is nowadays, it has become imperative and important to devise a robust regulatory and ethical framework to mitigate the risks posed by the AI while maximizing its benefits. AI systems should be designed in a consonance with human values and rights and ethical principles such as fairness, transparency, accountability, and must be embedded in AI development process. AI should not infringe upon the right to privacy, the right to equality and non-discrimination, the right to a fair trial, and other essential human rights. AI must be used to enhance and not diminish idea of freedom. AI can be considered as double-edged weapon in the realm of human rights. Artificial intelligence offers immense potential to enhance human welfare, but unregulated artificial intelligence may pose significant risks and undermine fundamental freedom. To strike a balance between innovation and ethical governance is imperative to ensure that AI serves as a tool for human right protection rather than a catalyst for their erosion. As Justice Nina has mentioned, when I received the invitation and I was supposed to speak on the topic in the valedictory function, so I asked one of my former law researchers to give me some material on artificial intelligence and human rights. Within half an hour, he sent me an article on artificial versus human rights. I wonder how he could manage such a wonderful, intelligent student, my law researcher. Then my son, who is a computer engineer, he said it is a game of artificial intelligence. But I did not rely. I did my own research and find out some material on artificial intelligence in context with the human rights. In this valedictory function, I also take the opportunity to say a few words with law teachers. I myself was a law teacher way back in the 1992 in Campus Law Center. Few days back, I was addressing one program organized by All India Law Teacher Association. I raised few points for young law teachers, as many young law teachers are sitting before us. I said we need to develop a national policy on legal education. We also need to have a quality legal education, and all law teachers, they also required to update their legal knowledge as well as also to improve their teaching skills. I have noticed many law teachers, they may be good in knowledge, but when it comes to deliver to the student, they are not up to the mark. So we need to improve our techniques, how to teach, and our teaching skills also. And simultaneously also, we also need to develop a very good legal literature on different issues. Today, we are lacking good legal literature on different subjects. So it's a bounden responsibility, a pious duty on the law teachers to prepare the good legal literatures. Also, I also grabbed the opportunity to say a few words to the law student, those who are present in the laws in the large number. You are the future of our judicial system, judicial process, and the legal system also. You need to shoulder the responsibility for the future. My message to the law student, to prepare yourself for the tomorrow. If you want to perform tomorrow, we need to prepare today itself. You need to do hard work. You also need to value the time. I always follow the punctuality. Try to follow the punctuality and time management also. Every day is the day of learning. Always be ready to learn every day the latest development in the law. We are living in the period of globalization where the world has become like a small ball. With the advancement of the communication and information technology, we need to learn every development in the law. In the past few years, we have seen the development of the cyber law, alternative dispute resolution mechanism, and now what we have discussed today, the emergence of the artificial intelligence and its impact on the judicial system, judicial education, legal system, and judicial process also. And simultaneously, we also need to have good company. A good company, a good friends also teach us a very good learning in our life. So as you are the future of this country, you are having a very bounden and very onerous responsibility on your shoulder to shape the future of this country for tomorrow. In the end, I can say, after watching the performance in the morning, I can say the participation in the moot court competition helps in the overall development as a good and proficient lawyer and makes a student familiar with the proceedings of the real courtroom. Mooting helps in the developing confidence in articulation of argument and drafting skills. And the memorials which were placed before us today in the morning, they were the classic example of the exhibition of the drafting skills. But in the morning, I mentioned few points to the participant of this moot court competition. Now, the present moot court competition is an integral part of the legal education. Now, what is the requirement of the day? The high quality legal education is prerequisite to high quality legal practitioner. The present competition is a step in right and meaningful direction to accomplish the goal of standard legal education. Once again, I congratulate each and every one who is directly or indirectly attached and connected with the successful completion of 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights 2025. And once again, I express my deepest gratitude and thanks to the organizer of this program, and specifically to Madam Shivangi Sinha, who invited me for this program. I'm really thankful to all of you. Thank you very much. Good luck to all of you. Namaste.
Thank you so much, sir, for your such deep words. Indeed, sir has rightly pointed out that AI should be used to enhance and not to diminish our freedom. And as law students, we need to prepare today to make a better tomorrow. Now, I would like to invite Honorable Justice Ujjal Bhuyan, sir, Judge, Supreme Court of India, to guide the audience as well as the judges from his rich experience in the legal fraternity. Please, sir.
Justice Raja Karuna, I hope my pronunciation is correct, Judge, Supreme Court of Sri Lanka, my sister and brother judges of different high courts of this country, former Judge Justice Jain, Mr. Jai Kumar, the Registrar of Bharati Vidyapith, Dr. Ujwala Bindale, the Dean and in charge principal of the new law school, law college of Bharati Vidyapith, Dr. Jyoti Dharam, the vice principal, faculty members who are present here, members of the bar, my dear students, ladies and gentlemen, a very good evening to all of you. It is indeed a privilege to be in such a great institution, Bharati Vidyapith. So I thank the university management for giving me an opportunity to come here to visit the university and share a few of my random thoughts with all of you. This is not my first visit to Pune. I have been visiting Pune quite often. But first visit, today I went to the bar and now in this university. I also take this opportunity to pay my homage to this great visionary, Dr. Patangrao Kadam, because of whose vision we have this great institution today. Dr. Kadam had a dream. In fact, today, before coming here, we were watching the documentary on the Vidyapith. In the campus, I am told there are 25,000 students. In the residents are about 25,000 in the campus. Certainly, it's a very, very big university. About 2-3 weeks back, I was there in Parul University in Vadodara. There I was told they had about 22,000 residents. So here I am, 25,000 residents. And there are 8 other campuses too. It will be much more if we count all those campuses. And the university budget, only budget of the university is 1,400 crores. So this is quite a huge university, and so therefore I'm very happy that I'm here to share my thoughts and experiences with you. Already my previous speakers have already spoken about mooting. They have spoken about artificial intelligence, also generally about law students, also over the faculty. So I will not go into all this. I will primarily focus within the limited time frame that we have. That's again another important aspect of lawyering, time management. Within the limited time frame that I have, I will focus on this basic topic of human rights. Now, when we speak of human rights, we often speak of Justice Krishna Iyer, undoubtedly, there's no doubt about it. Also, we speak of Justice H.R. Khanna. But we should not forget the seminal role played by Justice P.N. Bhagwati. It was he, through his very liberal and innovative judgments after emergency, post-emergency, which had opened up the entire sphere or space of human rights. I'll come to this a bit later. A couple of months back, Mr. Kailash Satyarthi, you must have heard his name, the Nobel laureate, a child rights activist, and I have been knowing him since my Guwahati judge days in 2011. He said, I would like to meet you. So I said, oh, you're most welcome, come over. So he came to my house in Delhi, and he said, my organization, this child rights organization, we are planning to have a roundtable conference in Delhi. The idea is to bring in compassion in the justice delivery, compassion in decision making, judicial decision making. So I said, I'll go. It was moderated by Justice Hima Kohli. She has recently retired from the Supreme Court. We were 10 sitting Supreme Court judges who were present there. It's not necessary to name who were there. I was also there. And we had also large number of retired judges of the Supreme Court who were present. Justice Kurian Joseph, Justice Madan Lokur, Justice Sikri, Indira Banerjee, they were there. The idea, as I said, was to bring in element of compassion in judicial decision making. So when my turn came to speak, I said that we are now in the 75 years, we have completed 75 years of our constitution. I said, as students of law, we need to introspect. It is no good. Undoubtedly, we have traveled a long, long way, but it is no good all the time patting our own backs, saying that we have done this, we have done that. Supreme Court of India is the most powerful court in the world. It is. But at the same time, we need to introspect whether or somewhere down the line, we have gone wrong. Only if we do that, only if we introspect, then only there can be course correction. And I am sure, and I have the firm belief, there is enough room for course correction in the Indian judiciary, which we have today. As a Supreme Court judge, sitting Supreme Court judge, I have no hesitation in saying Supreme Court is supreme because it is the final court. Had there been any other court above the Supreme Court, like the Privy Council of yesteryears, many of the judgments of the Supreme Court perhaps would have had to suffer a relook. Why I am saying is this: as students of law, we need to develop a critical mindset, a questioning mindset, and not to lap up anything and everything what comes, including judgments of the Supreme Court. We need to critically analyze whether these judgment, what is this, what the judgment lays down. Of course, we know that the criticism of the judgment has to be on the firm legal basis. We have to give reasons, and we cannot impute any motive. So therefore, wherever I go, after I became a Supreme Court judge, I have received many invitations. At least 15 universities I have visited. I always tell my students that please develop a mindset which questions, a questioning mindset, and critically look at the judgments. Many of the judgments, I had said in the recent meeting of the Indian Law Institute in Bhagwati, where Justice Oak was also present, we need to, the recent judgments which have come out, we need to have a critical examination of these judgments. Now, coming to the topic of the moot court competition, my previous speakers have said the importance of mooting and how well you have prepared and how well you had presented. So I must congratulate all the participants who have come from different law colleges and universities across the country and abroad. Winning and losing is immaterial, as has been pointed out. It is the experience that you will take back which is very important. As you step into the legal profession, you will soon realize that you are not going to be in each and every case that you argue. So therefore, you must be able to take in your stride the setbacks that you may face in your legal career, and that too with a smile. Friends, when we speak of human rights, I'm not going to speak about the international scenario. We all know about the Universal Declaration of Human Rights and also the two covenants, because Human Rights Declaration was not a binding document. So therefore, in 1965, United Nations had two covenants, one on the civil and political rights and the other on the cultural and social rights. India is a signatory to both the initial 1948 Universal Declaration of Human Rights as well as the two covenants. And thereafter, since it is binding, our parliament enacted the Human Rights Act in 1993. Here we have got a definition of human rights. Not necessary to go into that. And also this act provides for constitution of human rights commissions at the national level as well as at state level. Now, when we speak of human rights, it is not that after the statutory definition of human rights and the Human Rights Act which came in, that we have started having the human rights discourse in India. In ADM Jabalpur versus Shukla, Justice Khanna, delivering the minority judgment opinion, had said that rights under Article 21 is inherent in a human being because we are a human being. It is not that the Constitution has conferred such rights on us. Constitution has only acknowledged such right. It is necessary to just go back a little bit on history. In 1975, internal emergency was declared. Couple of days later, a presidential notification was promulgated prohibiting access to the courts, even for a writ of habeas corpus. This was challenged by a journalist, Shukla, in the MP High Court, Madhya Pradesh High Court. A division bench of Justices A.P. Sen and Justice Tankha, they had ruled in favor of the petitioner, saying that even when there is an internal emergency in place, the right to access the courts cannot be denied to a citizen. The state challenged this before the Supreme Court. And by a majority of 4:1, this judgment was reversed, saying that when there is an emergency in place, a citizen has got no fundamental right to approach the court to seek a writ of habeas corpus. It is in that context that Justice Khanna had made the aforesaid observations that Article 21, the right to access court, is a part of our fundamental rights, part of our human rights. It is not that the Constitution has conferred such right upon us. It was there because we are human beings. Constitution has only recognized such rights. During the course of that hearing, the Attorney General was Nirende. And Justice Khanna writes, he has written in his autobiography, "Neither roses nor thorns." Khanna's nephew is our present Chief Justice of India. In his autobiography, "Neither Roses Nor Thorns," he has written that when this hearing was taking place on such a seminal topic of such importance, he was trying to understand the psychology of his brother judges on the bench. Either they were silent or they seemed to be tacitly endorsing the stand of the Attorney General. So he felt a little bit uneasiness. So he put a query to the learned Attorney General, Nirande. It was actually a query to his brother judges who were there on the bench. He put a query to the learned Attorney General, saying that, all right, emergency is in place now, whether a police officer without warrant can shoot a person. And the answer of very nonchalantly, Nirande said, well, when the emergency is in place, and question was shoot a person and whether the victim would have any right of remedy. The response was that the victim will have no remedy as long as the emergency is in place. Therefore, he decided that the way he was thinking, his would be a minority opinion. He beautifully, please go through this, those who can, who have spare time, please go through his autobiography, Neither Roses Nor Thorns. MC Chagla had written Roses in December, he has written this, Neither Roses Nor Thorns. So he said, I had written the draft, I had prepared the draft judgment, and this was before Baisakhi. He requests his wife and his sister to go to accompany him to Haridwar. There's a beautiful guest house. Whenever my the visitors come to me or my guests come, I always send them to that guest house. It's a beautiful guest house overlooking the Ganges. So on that moonlit night, all three of them were sitting there. And then he quietly told his wife and his sister that I have prepared a judgment. Mind you, Justice Khanna was next in line to be the Chief Justice of India. He said, I have prepared a judgment, but that judgment may cost me the Chief Justiceship of India. His wife did not say anything, his sister did not say anything. And the next day, the three of them returned to Delhi. Throughout the journey, all three remained silent. The rest, we all know, is history. Now, after the emergency was lifted, elections were held, a new government, Janata Party government, came to power. Menka Gandhi wanted to travel abroad. But the then government impounded her passport. So she filed a writ under Article 32 in the Supreme Court, saying that I have a fundamental right to travel, which is traceable to Article 21. And the right to travel includes right to travel abroad. By impounding the passport, you have violated you have infringed upon my fundamental right under Article 21. Other grounds were also taken. We need not go into that. So, the precise question before the court, this was a 7-judge bench, subject to correction. Justice Bhagwati was one of the leading judges there. The question was, what are the contours of the expression procedure established by law as it finds place in Article 21. Now for this, we again need to take a step back. In 1950, Mr. A.K. Gopalan, he was a communist leader from Kerala. At that time, it was part of the Madras province. He was arrested under a preventive detention law. Initially, he had filed a writ in the Madras High Court, and finally it came to the Supreme Court. He challenged his preventive detention as well as the Preventive Detention Act. Primary ground of challenge was that, again, what are the contours of this expression, procedure established by law? Gopalan canvassed the point that that procedure must be just, fair, and reasonable. Today, it appears to be just passe, this is acceptable. There can't be any other formulation. But during that time, if we are talking about 1950, when the Constitution was just adopted. But the majority repelled this argument. The other points also, the 14, 19, 21 are all interlinked. If there is violation of 14, it will lead to violation of 19. If it leads to violation of 19, it will lead to violation of 21. The majority said, no. All that this expression means is that there must be a proper valid law in existence. And that proper valid law must lay down a procedure. Once these two conditions are fulfilled, a person can be deprived of his life and liberty. They also said that principles of natural justice are too vague. This is trying to bring in through the back door the concept of American due process, which the Constituent Assembly had expressly rejected, that we cannot have, or we need not bring in the American concept of due process. Maybe it was the early days, as I said. The lone dissenting judgment opinion was that of Justice Fazal Ali. Justice Fazal Ali said that the law must be in conformity with the principles of natural justice. The law and the action both to meet the test of Article 21. He also said that, Then in R.C. Cooper's case, all of you may be knowing, the students of law would be knowing R.C. Cooper's case, the bank nationalization case, the first limb, that 14, 19, 21 are separate, they are islands, was repealed. This time, the Supreme Court said all these three articles are intertwined. Violation of one will lead to violation of the other. They cannot be read and understood in isolation. That's R.C. Cooper. Now coming back to Menka, the 7 judges bench held that the law must be fair, not formal. I'll just. It must conform to the requirements of fairness, non-arbitrariness, and by extension, compliant with the principles of natural justice. Friends, Menka Gandhi can be said to be the watershed moment of Indian constitutional history. It had unleashed the interpretive prowess of the Supreme Court. And since then, it has had the impact, multidimensional impact on our constitutional jurisprudence. Post Menka Gandhi, we had this public interest litigation jurisprudence flowering in this country. We had the human rights jurisprudence, I'll deal with this, then environmental jurisprudence, and electoral reforms. Now, human rights jurisprudence, Justice Krishna Iyer took over, where Justice Bhagwati took over, where Justice Khanna left, and Justice Krishna Iyer took over, where Justice Bhagwati left. Right to free legal aid, you all know, right to fair trial, right to a speedy trial, have all been held to be fundamental rights traceable to Article 21. Rights of the prisoners, be him an under trial, post conviction, or at the appellate stage. Bail jurisprudence, the famous saying by Justice Krishna Iyer that bail is the norm, jail is the exception in our country, and which 2024 in large number of cases Supreme Court has reiterated this principle. Supreme Court has also held that prisoners, just because they are prisoners, are not denuded of their fundamental rights. Certain fundamental rights, such as the right to life, pervades the prison walls. D.K. Basu versus State of West Bengal is an important case, please remember this, in which the Supreme Court said that custodial violence, including death, is one of the worst crimes in a civilized society governed by the rule of law. Any form of torture or cruel, inhuman, or degrading treatment would fall within the inhibition of Article 21. Supreme Court also issued a series of directives what is to be done post-arrest. D.K. Basu did not stop at that. It also endorsed the line of judicial reasonings or the principles formulated by the Supreme Court since Rudul Shah, then Neelabati Behra, that in a public law remedy, under the public law remedy, persons or victims who have suffered human rights violation can be compensated, or rather should be compensated, which will be in addition to the compensation under the private municipal law. Now, two issues I will flag off, that's all. Another issue which is intrinsically connected with this custodial violence and which is concerned with human rights is the issue of extrajudicial killings. According to National Crime Record Bureau data, NCRB data, during the last 2 years, cases relating to encounter killings shot up by 65.9%. However, between 2001 and 2018, only 26 policemen were convicted for custodial violence, though 1727 such deaths were recorded in India. And this despite guidelines by the National Human Rights Commission. In Prakash Kadam, again from Maharashtra, versus Ram Prasad Vishwanath Gupta, this is a 2011 case, Supreme Court declared in no uncertain terms that fake encounters nullify the very essence of the rule of law. Supreme Court used strong words in deprecating such practice and held that if a case of fake encounter is proved against a policeman in trial, it must be treated as the rarest of the rare case and death sentence must be awarded. This is Supreme Court saying in 2011. Encounter philosophy. There are trigger-happy policemen. Encounter philosophy is a criminal philosophy. It has got no place in a democracy and in a civilized society which is governed by the rule of law. Again, on a case from Maharashtra, People's Union for Civil Liberties versus State of Maharashtra, Supreme Court has laid down standard operating procedure for extrajudicial killings. So, this jurisprudence of human rights has evolved over the years. It has also spread its wings to other branches. For example, sexual harassment of women at workplace. In Vishaka, Supreme Court said that this is violative of human rights and therefore laid down guidelines under Article 142. National Legal Services Authority filed a social action litigation in the Supreme Court saying that we need to move ahead of the men-women binary. There is a significant population in our country who are, whom we derisively call the hijras, the eunuchs. They are human beings. But look at their plight. So in this seminal judgment of 2015, Supreme Court said that they will be considered as the third gender and they will be equal to all the rights and liberties as enjoyed by men and women. The scourge of manual scavenging. Just imagine, in 21st century, human beings carrying excreta of another human being. So in Safai Karamchari Andolan, Supreme Court said that this type of inhuman practice cannot continue in a country like ours. Finally, in K.S. Puttaswamy, he's a retired judge, Supreme Court declared that the right to privacy is an intrinsic part of the right to life, which is traceable to Article 21. According to me, this is one of the most outstanding judgments after Menka Gandhi. Its full impact will be seen in the years to come. Already we have seen, it has already been applied in Navtesh Singh Johar, a number of cases where we have acknowledged the LGBTQ rights, a number of judgments. Now, in a case relating to land acquisition, where the landowners were deprived of the adequate due compensation, Supreme Court in Lala Ram versus Jaipur Development Authority, it's a case from Rajasthan, said that though right to property, you all know right to property is no longer a fundamental right, but it is still a constitutional right under 300A. Supreme Court said it is nonetheless a jealous possession of which one cannot be divested except by authority of law. Without the right to property, other rights become illusory. Right to property is now considered to be a human right. It's a human right. Friends, as students of law, in recent times, we are witnessing a very disturbing and depressing practice of state authorities using bulldozers to demolish houses and properties of persons accused of committing certain offenses. Of course, it is defended, such action is defended by the state authorities by saying that these were illegal structures either without permission of the competent authority or that they had encroached upon land of others, maybe private, maybe public. One of my most favorite quotes, and somehow which is very close to my heart, is the one which is credited to William Pitt, the Earl of Chatham, which he had said in March 1763 and quoted with great approval by Lord Denning in 1964 in a case called Southam versus Moot. The quote is like this: "The poorest man may in his cottage bid defiance to all the forces of the crown. The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement. So be it, unless he has justification by law." Now, this quotation has been referred to by Justice Gawai in his recent judgment in the matter of demolition of structures. It's the 2024 judgment, you will find it. He has also referred to a poem, a Hindi poem by the famous Hindi poet Pradeep. And the poem reads like this: "Apna ghar ho, अपना आंगन हो, इस ख्वाब में हर कोई जीता है। अपना घर हो, अपना आंगन हो, इस ख्वाब में हर कोई जीता है। इंसान के दिल की ये चाहत है कि एक घर का सपना कभी ना छूटे।" So, loosely translated, it means that to have one's own home, one's own courtyard, is a dream which lives in every heart, and this longing never fades away. So therefore, in this judgment, Supreme Court deprecated such practice. This is unheard of. This is totally incompatible with our constitutional scheme. Supreme Court also looked at it from the angle of the right to shelter. In that house, all right, we assume that this person may be an accused or he may be a convict, but his mother stays there, his sister stays there, his wife stays there, his children stays there. What is their fault? If you demolish that house, where will they go? It is like taking away the shelter over their heads. I would add, why only them? What about the accused? What about the convict? Just because somebody is an accused in an offense or a convict, that doesn't mean that his house should be demolished. According to me, using a bulldozer to demolish property is like running a bulldozer over the Constitution. It is a negation of the very concept of the rule of law, and if not checked, would destroy the very edifice of our justice delivery system. Justice Chandrachud, in one of the judgments, one journalist, his house was demolished. So he had written a letter to Justice Chandrachud as the Chief Justice. Before leaving office, his bench had passed an order in which he says, justice through bulldozers is unknown to any civilized system of jurisprudence. Bulldozer justice is simply unacceptable under the rule of law. It violates human rights and human dignity. I will not speak about artificial intelligence, but artificial intelligence, friends, it has got positives, it has got negatives. We can use artificial intelligence to monitor violation of human rights in the country. We can use artificial intelligence to monitor functioning of the human rights commissions, whether they had responded timely and adequately to the cries of violation of human rights, violations. But there is a flip side too. There can be inbuilt biases fed into the data of the computer, which will lead to all kinds of biased results. So, plus and minus, we have to look at it and come to, it will, of course, it will require a very, very detailed discussion. It's just off the cuff, we cannot say. But at the end of the day, we are dealing with a human judge, we are dealing with a human lawyer, we are dealing with a human litigant. All three are human. I remember the late Ramakrishna Hegde, former Chief Minister of Karnataka. Elections to Parliament, elections to the State Assembly were held simultaneously. His party won all the seats in the parliamentary election, but lost the assembly elections. Same day voting. So he said, this is human mind, I can't understand, I can't read. He said, human mind is unpredictable. He said, human mind is an enigma, wrapped in mystery. You like somebody, you marry somebody. You marry somebody, you like somebody. So it's an enigma. But unlike the human mind, the judicial mind cannot be unpredictable. The judicial mind cannot be frail, cannot be fragile. There must be consistency in judicial decision making. There cannot be selective application of the law depending on the litigant before the court. The endeavor should always be to enhance our rights-based jurisprudence, including human rights, accretion to the rights, and not a rollback on the rights. I think this would be enough for the day. I thank the organizers for inviting me here to share my views. I have very strong views on human rights and liberty and free speech. And I wish all of you the very best in life. I thank the organizers for inviting me once again to share my views with you. God bless. Thank you.
Thank you so much, sir, for such, deep and gently crafted speech for the audience. How beautifully and wonderfully he touched upon what is law, like what is the role of compassion in judicial decision making, then critical analysis involved in law, and he beautifully, touched upon all the topics, what, constitutes human rights. Going through all the cases, we have ADM Jabalpur, Neelabati Behra, the right to compensation case, and all of that stuff. And lastly, he very well pointed out that how, technology should be used very wisely and should not be used recklessly. And he pointed, see, there are times when, years changes, so the law changes, as we say. So the code was referred from 16th century to 20th century, but the law changes from years and years. So thank you so much, sir. A huge round of applause for our chief guest again, please. Proceeding ahead, we are immensely privileged to extend our heartfelt gratitude to Dr. Ujjwala Bindale ma'am, our esteemed Dean and Principal, for her outstanding leadership and unwavering support in steering the 13th Justice P.N. Bhagwati International Moot Court Competition 2025 on human rights.
Her dedication to excellence and passion for nurturing legal minds have been instrumental in guiding us towards success. Her wisdom and encouragement has been a beacon of inspiration throughout this remarkable journey. It is now my honor to invite Dr. Ujjwala Bindale ma'am to present the official report of this prestigious event.
Thank you, Mukul. Thank you. Good evening, everyone. I know this is the last speech of the day, and it is my duty to give you the report of all the 3 days, and kindly bear with me for last 7 to 8 minutes, and then we will be going in for the ceremony. But before that, I seek pardon from the bench over here, because I'll be taking 7 to 10 minutes, and I'm really very sorry for that, but yes. So welcome to this valedictory function of 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights. As you know, I'm here to give you the report, but before that, I request all of you in this gathering to give a standing ovation to all the justices right from India to Sri Lanka for protecting the fundamental rights and human rights of all the citizens and individuals throughout the territory. Thank you everyone. Lordship and Ladyship, you are aware about Bharati Vidyapeeth. It is a multi-dimensional, multi-campuses university, and right from pre-primary to doctorate level, it has been conducting the education and has achieved excellence throughout. And there are 8 campuses within Maharashtra and 1 at the heart of the country and the capital of the country, that is New Delhi. But it is a matter of immense pride for me to inform you that Bharati Vidyapeeth has been recently accredited with A++ grade by NAC 2024, which is the highest recognition of academic excellence, quality education, and institutional performance. The legacy of this university is built upon the guidance and support of our esteemed patrons, Professor Dr. Shivajirao Kadam, Chancellor, Dr. Vishwajit Kadam, Secretary and Pro-Vice Chancellor, Professor Dr. Vivek Sauji, Vice Chancellor, and Professor Dr. Asmita Jagtap Kadam, Executive Director. Their unwavering dedication has propelled New Law College to achieve new heights in legal education and research. Lordship, our institution, New Law College, was founded and established in 1978 and was inaugurated by Honorable Mr. Justice Y.V. Chandrachud, the then Chief Justice of India. And now this institute is recognized for its international excellence in legal education. The institution has ranked amongst the top law schools in this country, and I'm very proud to inform you that this has been possible only because of my diligent students and dedicated staff who have initiated different cells and centers at this institution and have groomed the students to the best. New Law College, this flagship event of Justice P.N. Bhagwati International Moot Court Competition on Human Rights, it's not a mere academic exercise. Rather, it is a platform for participants to channel their passion for justice into actionable advocacy during driving positive change in the society. Lordship, the first P.N. Bhagwati International Moot Court Competition commenced in 2011 under the aegis of Honorable Dr. M. Virappa Moily, the then Union Minister of Law and Justice, and in the esteemed presence of Honorable Mr. Justice P.N. Bhagwati, former Chief Justice of India. Today, this competition has become one of the most revered international platforms for human rights advocacy. This competition has already completed 12 editions, and this year, the 13th edition, saw registration from 32 institutions around the globe. Lordship, the first day of this competition was commenced with the inaugural ceremony, which was graced by the presence of Honorable Mr. Justice Tek Prasad Dugana, Judge of Supreme Court of Nepal, and Honorable Mr. Justice Dinesh Kumar Sharma, Judge, Delhi High Court. We extend our heartfelt gratitude to honorable judges for gracing the inaugural ceremony of this competition. The day proceeded with the preliminary rounds being judged by various legal dignitaries ranging from academicians to associations and associates. Top 8 teams went to quarter-final rounds scheduled for the second day. Further, the second day proceeded with the extensive argument shared by the top 8 teams. The round was adjudicated by esteemed legal dignitaries hailing from 4 corners of India. Quarter-final rounds further narrowed the competition between 4 teams. While the judges were grilling the speakers thoroughly on the norms of international law and human rights, the researchers were being tested by the organizing committee for their individual rewards. The semi-final rounds took place in second half of 21st March 25, where 4 teams exchanged their rigorous contentions. The round were judged by a panel of 4 judge bench, came from different parts of the country. Their discerning insights and profound expertise served as a guiding light for the evaluation process, ensuring that every contestant's performance was scrutinized with meticulous attention, which gave us the best 2 teams for the day. Today, the third day, the most awaited final rounds were being judged by the 5 eminent panel judges extending from India to Sri Lanka. We truly are honored to have Honorable Mr. Justice RMS Raja Karuna, Judge Supreme Court of Sri Lanka, Honorable Mr. Justice Devan Ramchandra, Judge High Court of Kerala, Honorable Ms. Justice Neena Bansal Krishna, Judge High Court of Delhi, Honorable Mr. Justice Siddharth Verma, Judge High Court of Allahabad, Honorable Mr. Justice Sudhir Kumar Jain, former Judge High Court of Delhi. Indeed, the final rounds were engaging with diligent arguments, articulated contentions with a pitch of persuasion and lot of confidence. I hope that the judges are delighted to be the part of the final rounds. Thank you so much. Moving ahead, with the conclusion of this competition at this valedictory ceremony, we are blessed to have Honorable Mr. Justice Ujjal Bhuyan Sir, Judge Supreme Court of India, as a chief guest of this ceremony. I'm truly honored and grateful to honorable judges for taking out their time from their busy schedule and gracing the event with their appearances. I'm also grateful to the sitting panelists of judges who not only judged the competition but also agreed to stay with us for the valedictory ceremony and results announcement. I also express my gratitude towards the President of Pune Bar Association, Mr. Hemant Zanzade sir. Last but not the least, a big round of applause to the members of the organizing committee who worked day and night for months together in order to make this competition happen. As we stand today celebrating the success of this moot court competition, I would like to take a moment to express my heartfelt gratitude to few exceptional individuals who worked tirelessly behind the scenes to make this event a reality. With great pleasure, I would like to felicitate a few students from the final year and co-conveners for their individual contribution to success of this competition right from the start till the end. Dear students, your dedication, perseverance, and commitment to excellence have been truly inspiring, and I'm honored to recognize your efforts. I would like to call upon all the students one by one, and of course, I request Honorable Lordships and Ladyship to do the honors of felicitating the final year students who are going to go, but they're going to go with good memories, and of course, with the faculty coordinator, Dr. Shivangi Sinha. Please come upon the stage. Mr. Mukul Aryan, Dakshina Jain, Shikhar Rusia, Harsh Yadav, Adarsh Singh, Shivom Mishra, Shravani, Sarthak Sinha, Abhishek Sinha, Arundhati, Dev Kartike. Please be on the stage and receive your particular memento for appreciation and your contribution to the 13th International PN Bhagwati Moot Court Competition on Human Rights. Kindly, I request Honorable Lordship to do the honors to my students. Come quickly, Pam. Go one by one. Mukul, go ahead. Yes, thank you so much. Dakshna, Shikhar, Harsh, Adarsh, Shivom, Shravani, Sarthak, Abhishek, Arundhati, and Dev. Apart from this, I would like to extend my gratitude to rest of the core committee who are still going to be the part of this college and this competition in the beginning, upcoming editions. Your hard work and enthusiasm have been the backbone of this event, and I'm grateful for your contributions. Thank you once again. Thank you, Lordship. Now it is a proud moment for me to announce that an innovative task has been undertaken by our law artisan cell of New Law College, which is famously called as the AI cell, in creating a legal game named as Eloquent, reflecting upon court procedures through fictional cases based on factual situations. The script of this legal game has been remarkably crafted by Archie Agarwal, a BBA LLB third-year student of 5-year course under the guidance of Dr. Rashmi Dubey, the faculty coordinator of this particular cell. The efforts of Archie Agarwal are beyond words, truly outstanding and highly commendable. I request the cell members to present the demonstration of the game for better understanding.
Good afternoon, everyone. I, Ritiksha Singh, a fourth-year BBLLB student, member of Law Artisan Cell at Bharati Vidyapeeth, New Law College, Pune, will enunciate the demonstration of the game. Eloquent is designed to simulate general court proceedings in an engaging and interactive manner. The game presents fictional cases that closely resemble real-life legal scenarios, allowing students to experience court proceedings in a practical way. The game comprises of 20 levels, and you have to crack each level to reach out to the next level. While playing, students will navigate through the legal process, analyzing arguments from both sides. At the end of each session, there will be an MCQ-based quiz to test their understanding of the proceedings. This interactive approach ensures that students not only enjoy the game, but also learn courtroom procedures effectively. We encourage all students to download and explore this game on their mobile devices. Currently, it is available exclusively for Android users and can be downloaded from the Google Play Store. This presentation serves as a demonstration of the game, and we hope you all enjoy playing it. We also extend a special request to students from other colleges who are participating in this moot court competition to download the game and enhance their legal learning experiences. Thank you and happy learning through Eloquent.
Thank you. Thank you. Thank you. But take a note, the game supports the Android system and can be downloaded directly from the Play Store once the internal testing gets done. So with this, I would like to extend high appreciation and applause to the student founders of the Law Artisan Cell, Ishita Thakur, Utkarsha Singh, Shashank Kumari Rai, and Dishti Pandey for their honest and remarkable efforts in establishing and developing the cell, along with the dedicated guidance of Dr. Rashmi Dubey ma'am. Words fall short in expressing our gratitude towards this intellectual minds. Now I would like to call upon the students up and request again the lordships to do the honor of felicitating these 4-5 students for initiating this AI cell along with this particular eloquent game, which is going to be very interesting for the whole of law fraternity throughout. Along with Dr. Rashmi Dubey ma'am, I request Ishita Thakur, Utkarsh Singh, Shashank Kumari Rai, Drishti Pandey, Archie Agarwal to receive the token of recognition and appreciation for their incredible contributions to the law fraternity. They are the future innovative minds of legal fraternity, doing wonders, and I'm really glad that they have been groomed by Dr. Rashmi Dubey ma'am. Lastly, I express my gratitude towards all the dignitaries on the dais and off the dais for your consistent support and patience hearing and listening. Lastly, and before I rest my speech, in the garden of memories, each of you have planted seeds of joy and learning. Thank you for making our event blossom. Thank you, everyone.
Thank you, ma'am. Thank you, ma'am. Moving forward, we now transition to the much anticipated award ceremony to celebrate the exceptional performances that have defined this competition. I would like to warmly invite our conveners to join us on stage.
For the award of the Best Researcher of 13th Justice P. N. Bhagwati International Moot Court Competition on Human Rights, we have Team code 1332, Nisha Adhikari from Nepal Law Campus. I would like to request Honorable Mr. Justice Ujjwal Bhuyan sir to kindly felicitate the best researchers. Now for the best speaker of the 13th Justice P.N. Bhagwati International Moot Court Competition, we have team code 1316 Ayush Kumar Jha from Lloyd Law College. I would like to request Honorable Mr. Justice Devan Ramachandran sir to kindly felicitate the best speaker. And Best Memorial Award goes to team code 1312, ILS Law College, Pune. May I please request Honorable Mr. Justice Siddharth Verma to felicitate the team. Now, before announcing the winners, we have a small twist. That is, there is one international team that has exceptionally performed well. And so we have been, felicitating the team with a token of gratitude and appreciation towards them. So the Best International Team Award goes to, again, Nepal Law Campus, team code 1332. May I please request Honorable Justice Ms. Neena Bansal Krishna to please felicitate the team.
I request all the honorable justices to please step forward. Registrar Sir, Dharma Ma'am and Bengali Ma'am, please step forward for the final verdict of the winner. And the winner of 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights Law 2025 is Team Code 1306. Symbiosis Law School, Pune. Last but not the least, the runner-ups of the competition is Team Code 1317. I request the runner-ups to please step forward. Team 1317, National Law University, Nagpur.
Hello. Congratulations. Hello. 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 Yeah. Congratulations to all the teams who have received or achieved awards, and many more congratulations to the learners. As Justice Devan rightly said, that learning and experience holds a more significant value.
As we proceed, the moment has arrived for one of the most crucial and heartfelt tasks, expressing our sincere thanks to everyone who has directly or indirectly contributed to the success of this event. For this, I would like to invite our guiding light, Dr. Shivangi Sinha ma'am. Not only she has served as the faculty convener for this competition, but she has also been our pillar of support, holding us together through challenging times and guiding us with unwavering dedication. Thank you so much, ma'am, for your invaluable support. I now extend my invitation to you to propose the vote of thanks.
Thank you, Ishika. Thank you so much. Lordship and Ladyship, I'll keep it very short. Good evening to one and all present. On behalf of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, I extend my heartfelt gratitude to all our esteemed founder and Chancellor, Dr. Patang Rao Kadam, Dr. Shivaji Rao Kadam, Chancellor, Bharati Vidyapeeth, deemed to be University, Dr. Vishwajit Kadam, Pro Vice Chancellor, Dr. Vivek Sauji, Vice Chancellor, Dr. Asmita Jatap Kadam, Executive Director, and Mr. G. Jayakumar, Registrar, without whose unwavering support, this event would not have been possible. Thank you so much, sir. To all the dignitaries on the dais from national and international arena who has taken out time from their busy schedule to be the part of the final and valedictory ceremony of the 13th Justice P.N. Bhagwati International Moot Court Competition on Human Rights 2025. First and foremost, I express my sincere appreciation to our Dean and Principal, Dr. Ujjwala Bindale ma'am. Thank you so much, ma'am, for her visionary and leadership and, of course, guidance throughout. I also extend my thanks to our Vice Principal, Dr. Jyoti Dhar ma'am. Thank you so much, ma'am. And Dr. Vidya Dhere ma'am, of course, ma'am is not here, who is our IQSC coordinator, for their constant encouragement and support. Thank you so much. I extend my heartfelt thanks to all the judges and the legal professionals who graciously dedicated their time and expertise to be the part of this international moot court competition. Your presence has elevated the standard of this event. Thank you so much, everyone. Once again, I sincerely thank Mukul Arya for formulating the proposition and appreciate the efforts of all the other team in drafting the charter and all the crucial documents for the competition. I know you have heard a lot from me. I apologize for that. To the students, the heartbeat of the competition, your participation, your enthusiasm, dedications are truly commendable. Congratulations to all the winners, runner-ups, and all the participating team. Your spirit, engagement made this event memorable. Congratulations to all. My vote of thank is going to be incomplete if I don't mention my conveners and co-conveners for the event, that is Dakshina, Mukul, Shikhar, Abhishek and Arundhati, who has given all in their managing and executing this event. Along with this, I would also like to thank all my committee heads, including the food, travel, management, court clerks. Thank you so much for all your support. A special word of appreciation goes to all the organizing committee, volunteers. Your tireless effort and commitment ensured the smooth execution of every aspect of this competition. So thank you so much. And next, I would also like to take a moment to appreciate Garvit, Saksham and Vedant. They were the one who actually made the documentary, and this is the one which was being shown to each and everyone for the moot court problem. So thank you so much, all three of you. In closing, I would like to express my gratitude to each and everyone who is involved in this competition. Your support and dedication laid the foundation for a brighter future. Thank you so much.
Thank you, ma'am. I now kindly request everyone to rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Ma'am, please.
I request. Hello.
Ma'am.
Hello. Hello, all the faculty members, please come on the dais on the stage for a photograph, please.